Delivery of order, item number 1.
This I have to deliver on next Monday. I could not go through the judgment.
Okay.
So it will be delivered on next Monday, 24th.
I have also provided a copy of the judgment to.
You have
Lower council.
furnished it yesterday evening.
Yes, Your Lordship,
So I
just
could not go through it
understand.
on next Monday.
Thank
Yes.
Well, I'd like to mention listing of an IA, my lord, on Friday. Emergency.
Okay.
May I please, Your Lordship? I beg to mention for listing of a CRP, Lordship, for orders, because for motion, I never listed. I am appearing for respondent, Lordship. More than 1.5 years, they are enjoying the stay order
CRP in motion column it,
No. for orders.
next week.
Obliged.
My lord, I beg to mention one CRP for listing, my lord, any day before 27, my lord, next week. There's actually 27 is the date in the lower court, my lord,
Next week on a date to be fixed by the minister.
before 27.
Okay, before 27.
Much less. Please, Your Lord. My lord, I beg to mention item number 8. My lord, I am appearing on the request of one of the engaged counsel, my lord. We have taken consent, they have taken consent of the appellant, my lord. Seek an adjournment.
What is your name?
My lord, I am A. Bhatra.
Heard Mr. A. Bhatra, learned counsel for the
My lord, I am not the counsel, my lord. I am appearing on behalf of.
appearing on behalf of Mr.
A. Sattar, my lord.
A. Sattar, learned counsel for respondent number 1 and 2, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. He submits that he has informed learned counsel for the petitioner regarding his prayer for adjournment, who does not have any objection to the said prayer. Hence the prayer is allowed.
Lord, my lord, as is a part third matter, if the lordship would like to fix a date.
No, part heard. Let this matter be listed in the next week on a date to be fixed by registry.
I beg to cancel for listing on to CRPIO on Amazon Colonel. So any day on next week.
Next week.
May it please, Your Lordship, I beg to mention one IA in RSA, Lordship. Right? Lordship, it is a fresh matter, filed on 15.
Next week.
Lordship, I have a similar prayer, Lordship. Another IA in a review petition.
Next
It's a fresh matter.
Next week dates will occur soon. Okay.
May I please, Your Lordship? I am begging for item number 41. The matter is wrongly listed, Your Lordship, in before this bench.
Why?
Because it's a matrimonial appeal and the matter is on division bench.
Item number 40.
41.
It is from family courts.
Yes, Your Lordship.
Heard Miss, what is your name?
Espal appearing on behalf of Mr.
Heard Miss
A.
Eswal, learned counsel appearing on behalf of Mr. A. Bishwas, who submits that since the matter pertains, this instant matter pertains to an appeal from an order of the family court, this matter ought to have been listed before division bench. Stop registry to verify and list this matter before appropriate bench.
I look.
Item number 14. My lord, I want to bring on record the evidence in this case by an evidence, additional evidence. So the matter may come after 1 week.
Heard Mr. M.J. Kadir, learned counsel for the appellant, who prays for allowing the appellant to file an additional affidavit to bring on record certain relevant facts, and hence prays for some time for the same. The prayer is allowed. Let this matter be listed after review.
Wait, your lordship, lordship, I beg to mention for listing of an IA for orders on Monday, lordship.
Not fixed date, in the next week.
For Wednesday. For early hearing, lordship.
Okay, Wednesday.
Yes, lordship.
Mayor, your lordship, I beg to mention for item number 44, lordship, on behalf of Bikoshi. Seek for the adjournment, lordship. The
Item 44. My lord, in this item 44, my lord, we have some objection. Let it come up when it comes up, my lord, because they have violated the order of the injunction passed by this honorable person.
Okay. We will pass the orders when the matter is taken
for.
up.
May I please, your lordship, I beg to mention one item for listing criminal petition next week.
Okay, next week.
Lordship, similar prayer in WPCCR.
What matter?
Lordship, this matter was on 13
What matter
August.
you want to?
Criminal petition.
Criminal petition, this is wrong court. You have,
WPC.
My lord, I'm praying for listing. My lord, I'm praying for listing of a motion coming Monday, 24th. CRP, it's a civil division case.
motion. Okay,
Maybe lordship, I beg to mention for the withdrawal of RSA 228 of 14
when?
on 21st.
Okay,
Your lordship, I would like to mention one RSA and one RFA matter for listing. Your matter may be allowed on any last week of November.
okay, last week of November allowed. Why are you withdrawing?
No, because my lord, I think in the original court there, I have to file in the, by applying inherent power, what the Supreme Court says. That also I can do, my lord. In inherent power. Applying by filing a separate suit to recall the judgment and all.
No, we are not mentioning anything. We are just allowing your prayer for withdrawal.
Liberty to file there, appropriate application, that much only.
You are
Appropriate application will do the purpose.
heard Mr. B. Sinha, learned counsel for the petitioner, also heard Ms. S. Roy, learned counsel appearing for the caveator. The learned counsel for the petitioner has prayed for allowing the petitioner to withdraw the instant civil division petition with liberty to file an appropriate application for seeking before the trial court. The prayer is not opposed to by the learned counsel for the caveator. The prayer is accordingly allowed. This civil division petition is accordingly dismissed on withdrawal with the liberty sought for granted. The caveat also stand discharged.
All right.
Item 55 for withdrawal.
Next, your lordship. I have the instructions to withdraw this petition with liberty. Some talks of compromise are going on between husband and wife, my lord.
What liberty?
They are trying to settle the dispute mutually, my lord. So perhaps they will be filing mutual divorce.
Okay.
The transfer petition, my lord.
Heard Mr.
RS Mishra.
R.S. Mishra, who prays for allowing the petitioner to withdraw this transfer application as a talk of compromise is going on between the parties. He also seeks liberty to file a fresh application if the if the attempt of settlement fails, the prayer is allowed. If the attempt at arriving at a settlement fails, the prayer is allowed. This application is accordingly dismissed on withdrawal with the liberty sought for granted.
Mutton দিয়ে item 3.
May I please, your lordship. Lordship, the petitioner or lordship behind the bar since 227 days, lordship. Lordship, commercial quantity NDPS, lordship. Scan copy may be called for, lordship.
Why before this court? Earlier rejected? What is the name of the petitioner?
Lordship, there are two accused, lordship. Two petitioner, lordship. Amirul Islam and Ashraf Ali, lordship. And in this case, lordship,
Okay.
from one petitioner,
Heard
lordship,
Mr. K. Thakur, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. Call for the scanned copy of the trial court records along with the scanned copy of the connected case diary. Registry to take steps for requisitioning the scanned copy. Release this matter on 17th of December.
deeply obliged.
Item 56, 57 and 58. Reading here.
Right, please, your lordship. Lordship, on earlier occasion, my lord, I am appearing for my senior A. Ahmed. Due to some difficulty, he could not come, my lord. And earlier occasion, my lord, your lordship has recorded the submission of Mr. A. Ahmed, my lord, in connection with item number 56 for petitioner number 1 and 58, my lord.
We are taking up item number
56, 56, 57, 58.
one by one.
56, my lord. I'm for petition number 1 in 56, my lord.
What are the materials against them?
Lordship. This 56, these two are the handyman's lordship. And they were present at the time of Third's lordship, recovery of the test fund. And item number 58 is the Sahabuddin, he is the driver. And this one, 57, Ziaur Rahman, he is the receiver lordship. So as per I have gone through the scan copy lordship, I have seen only three or four things lordship. The statements of the accused persons are there lordship, and the Caesar witnesses statements are there, and there is nothing else lordship. As per that lordship, it has only stated that this person has been Uttam, and only this person is present. Other materials I have not found, as per record lordship, what I have found.
Then why charge sheet has been laid? Only because he is the handyman.
With the handyman, as per lordship, scan copy, I only found that only lordship. There is nothing, any linkage lordship. And moreover, 47 and 48, they have also raised question lordship, but I have not found it. Now, neither 47, neither 48 in the scan copy. But these two persons are there, Uttam and lordship, this one. So few.
In the order of the learned trial court also, it has reflected lordship. These two persons were present,
Where is the trial court's order?
lordship. In page 19, lordship. This is the type copy 19 and 22 is the copy lord.
Okay, you flag the relevant,
I flag lordship, already flagged
I'll go through it.
lordship.
Others, what are your submissions?
I am the petition number 2, in item number 56, Tofur Rahman. And he is the handyman, and the submission on last date, I am supported that submission. And our case is that the contravention article were seized from the backside, that is the diggy of the bus, and which was kept in a bag.
So you kept that,
May not be, because we are somebody they kept in the diggy. The bag was kept. It is our duty to keep the articles of the passenger in the bus, but we did not find the inside of the bag the contravention article were there.
It is in the dicky, it is not stated here, lordship. It is in the back stated,
backside of the
not
bus,
dicky, it is not there.
Diggy is not there, but in the backside.
Backside of the bus may be also there, not in the dicky.
55.
In the,
Itu Kiman? Okay.
so nothing was required from the position of the petitioners, and they are in jail since 11/4/2025. 222 days, more than 7 months.
Where is the rejection order?
That is page 19, with the type copy, the original copy at page 22.
In page 20, para 3, lordship. As per the CD, it is written, lord. Page 20, lord.
Yes.
In the middle, somewhere in the middle. Lord. As per CD.
Is it your plea that this does not belong to you?
Because any passengers, because it was inside the bag. It is not a polythene bag or
But
it
no
is a-
passengers were there,
it is a
lordship.
bag.
At that time, it was
So-
standby.
It is not the handyman.
Okay,
but
I'll
it is
go.
not the passengers.
I'll go through the
Okay.
records.
Okay.
Yes, your case. Item number 57. Who are you?
I am for the Tofur Rahman petitioner.
He's the receiver, lord.
Lordship, here I was, I'm a student of third year BA third year third semester.
On what basis he was arrested?
It is only stated that lordship, he was a supplier and he is in the nearby in the lodge, lordship, in the ISBT. He was, and another person is also there, observed. He cannot be arrested, lordship, and he is to receive and distribute to all these persons. He's one of the receiver, Lordship.
Lordship, that
But how he came to know this, it is not there, Lordship. I have not found.
Lordship, that on that I came in Guwahati for receiving my mobile phone, which was under the repair, which was in repairing center. So for that I came, but suddenly I got arrested from the lodge.
Okay, on 24. 24. Mr. What is your name? Yu Khan, London Council for the Yu Khan, as well as Mr. D.A. Qayyum, Learned Counsel for the petitioners. Also heard Mr. K.K. Das, London Additional Public Prosecutor. List this case for delivery of orders for 11. On Monday, I will deliver. 24/11. And in this item number 57, what is your name?
Alok Deb, on behalf of MU.
What is your name?
Alok Deb.
Alok Day. List it on Monday. And same order. Who is for 58? 57. There are 3 items.
56, 57 and 58.
He is the driver, Lordship.
Who is for Shahabuddin?
Yes, I am for Sahabuddin. Sahabuddin is the driver, man. And he was picked
And
up.
for Uttam Nath?
So I am also for Uttam Nath, petitioner 1 in 56 item number 2513.
Okay. Same order, 58. Yu Khan. List it on Monday.
Lordship, my objection only on that 37 is also applicable there. Since it's a commercial.
My lord, another aspect is there is no antecedent of the petitioner, my lord, in another case, my lord. That may be considered also. Considering the length of detention is 202 days.
Okay, I'll go through the records.
May it please your lordship. My lord, in the present petitioner, my lord, he preferred an application under section 11. And he's the principal defendant of the title suit 7 of 2020, my lord. Then, my lord, respondent side also had an objection, my lord. Thereafter, impugn order dated 21/12/2020 has been passed, my lord. The condition laid down for the under section 11 has not been thoroughly discussed in this matter. Then we are subjecting another 2 orders passed relying of this that impugn order. So now the
Which order you are impugning?
yes, at page 48, my lord. Annexure 5. It is 21/12/2023. May I read the order, my lord?
Yes.
Today is the date fixed for necessary order. Both the parties are duly represented. Heard both the sides. Defendant side filed a petition number so and so by stating that the plaintiff side filed a title suit number 90 of 1992 in the Court of Civil Justice number 1 Kasar Silchar, which was decreed in favor of the plaintiff by the Honorable Civil Justice number 2 of Kasar Silchar. Thereafter, the defendant petitioner preferred an appeal before the said judgment and decree before the District and Session Judge Kasar. Honorable District and Session Judge allowed the appeal of the defendant by order dated 5/12/2001 by setting aside the judgment and decree of title suit number 20. Thereafter, the plaintiff side preferred an RSA of 65 for 2022 before the Honorable Guwahati High Court against the judgment of the Honorable District and Session Judge Kasar Silchar in title appeal number 20. Honorable Guwahati High Court dismissed the said appeal preferred by the plaintiff and thereby decided the matter finally in favor of the defendant petitioner. The defendant petitioner prayed to declare the present suit barred by the principle of res judicata as the matter directly and substantially in issue in the present suit has been directly and substantially issue of title suit number 90 and 92. The plaintiff side also filed an objection petition against the petition number so stating that the defendant petitioner filed an instant petition number so dated 16/12/2022 with a photocopy of the decree of title suit number 22 without any documentary proof, which is not sufficient to entertain the maintainability. Moreover, the plaintiff side also stated that the subject matter and the issues of both the suits are different and the parties are also different, for which the section 11 of the CPC is not attracted and the applicable of the present suit and the petition number 20 liable to be rejected. Now findings below. After going through the documents and the hearing both the sides, it is seen that the instance is filed by the plaintiff for declaration of right title, interest, and confirmation of possession of that numbers. One more, if I am 135 milot and so, but 140, I am relying 135, 147, 437 has not been recorded here, milot. Whereas title suit number 992 was filed by the plaintiff for cancellation of the sale deed number 135 and 147. Considering the subject matter and issue in both the suits are different and the parties are also different, for which the section 11 of the CPC is not attracted and applicable in the present suit, the instant suit is not barred by the principal res judicata as the matter direct substantially in issue in the present suit has not been directly and substantially issued title suit number 20.
Where is the fault?
Yes, my lord. My lord, the present instant pending plaint, kindly have a look at page 13 below and prayer at page 2022.
Present case is for cancellation of sale deed.
Yes, my lord. Prayer number can live in, my lord. Prayer number B and C, my lord. Then I'll take your schedule. Prayer number B, my lord, at page 22.
But relief is different. Earlier,
But I'll show you, lord. Same plaint, 1992, I have annexed here, my lord. I'll show you, lordship. B, my
okay,
lord.
okay, we are issuing notice.
My lord, next date fixed on 22nd December, cross of with plaintiff, my lord. So,
Now let the suit proceed. If ultimately
my lord,
you are found to be successful, it will be barred.
but sounds being good. That judicata already the court has rejected our that plea. We cannot take evidence of this plea, my lord. So it will be very great when irreparable loss to us if we cannot put any question evidence so far as on res judicata, so far earlier suit is concerned. Below some protection is necessary in this matter, my lord. Otherwise, when the whole case will be
No.
and my lord, and subsequently through another order passed relying the same order, my lord, our prayer has not been considered. We have filed CRP which is pending, my lord, it to be yet to be registered, my lord. So, my lord, some protection, my lord. Otherwise, if the plaintiffs allowed to go, if we don't able to put question on the cross, my lord, then otherwise whole case.
Why you will be barred from putting questions?
Since, my lord, this order, impugn order itself has not considered that plea.
No, only your prayer for res judicata has been considered.
Then we are unable to take any evidence or put any question on this point.
Why? Where is the bar?
Then they will say, plaintiff will say already this question already answered by that court, Miller. You cannot put up this question like this, Miller.
No. Heard Mr. P.K. Deka, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner who is aggrieved with the order dated 21/12/2023 passed by the Court of Learned Civil Judge Junior Division Lakhipur, Kachar in title suit number 7/2020, whereby the plea taken by the present petitioner that the title suit number 7/2020 is barred by res judicata was dismissed by the trial court. After hearing the submissions made by learned counsel for the petitioner, this court is inclined to examine the contentions raised by the learned counsel, hence issue notice to the respondent.
Records, please.
Respondent.
Scan copy of the record.
The petitioner shall take steps for issuance of respondent, issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order,
my lord.
returnable after 4 weeks. Returnable on 18th of December 2025. Let also the scanned copy of the records of the title suit number 7/2020 be called for on the trial court. The registry to take steps for requisitioning the aforesaid records.
My lord,
List as well.
my lord, may I beg one prayer, my lord? My lord, since on 22nd fixed for the cross-examination of plaintiff, my lord, so there is no bar to take any plea so far as res judicata question. It is open by this court, my lord, for us. Then it will be
Now, why that observation is
otherwise,
necessary?
my lord, they will stop on very same day if we put any.
You convince the trial court.
Yes, my lord. If not, my lord, I will.
If
Take-
trial court puts any restriction, then come to this
Yes,
court.
Diplo. Diplo.
Lordship, this revision petition under order Article 227 has been preferred against the order dated 18/7/2025. Passed in Midge case number. Midge case number so and so. Praying for a local commission in respect of the suit property, northern side of the suit property. The suit was filed by the respondent, stating that the district administration on 28/10/2014 demolished the northern wall of the petitioner's lands, the respondent's land, for widening the road and as well as removing the obstructions. That suit could not be contested because the trial court did not allow the respondent states, defendant state to file the WS within time. And accordingly, suit was decreed. Thereafter, this revision of appeal was filed before the Honorable High Court on the point of pecuniary jurisdiction that was transferred to the district judiciary, district court. In the district court, the state filed a petition under Order 26 Rule 9. Subsequently, another petition was filed.
District court, at what stage the trial is
It is
pending?
in appeal hearing now.
The appeal is pending.
Appeal is pending.
You filed an
Application.
application under
26 Rule 9. Subsequently, it was filed under Order 18 Rule 18. Because the court has, Honorable Court has the power of inspections. My only plea is that in the northern side, if it falls within his partial land, we have to pay. If it is within the government land, and it is not that when the demolition was carried out, it was not the district administration alone. National Highway Authority was there, and it is governed by the National Highway Authority Act 2002. Control of National Highways Land and Traffic Act 2002. National Highway was not a party.
when is the next date fixed?
It is on 18/12.
Okay, we issue notice. Heard Mr. B.K. Bhagavati, learned counsel for the petitioner. This application under section 220, under Article 227 of the Constitution of India has been filed by the state of Assam and one more petitioner
Two more petitions.
and two more petitioners impugning the order dated 18/7/2025 passed in Ms. J case number 83/2024 arising out of title appeal number 30/2024 pending
23.
2023 by the Court of London District Judge, Kamrup Metro, whereby the prayer for appointment of a commission to make local investigation of the suit property under Order 26 Rule 9 and 10 read with section 107 and section 151 of the Code of Civil Procedure 1908 was rejected by the trial court. Issue notice to the respondent. The petitioner shall take steps for issuing notice upon the respondent by speed post within 3 days from the date of this order, returnable on 16th of December. Record would be necessary,
Record, not necessary, may not be necessary. In case it is required.
then we'll see.
Lordship, only even they prayed for, there was a prayer in that suit also, that local inspection is necessary.
The appellant also, the respondent also prayed for.
Prayed for local inspection in the suit. So the prayer.
Okay, let him appear, or
Lord.
let list accordingly. Yes,
May it please the Lord. My Lord, impugn order is at page 135. It's just a registration of a petition in the form of miscase pursuant to an application filed by respondents number 1 to 7 herein under section 144 CPC for restitution of possession over the decretal length. Now, your lordship will just
where is the impugn order?
at page number 135.
135,
It's just
all order.
it's a small order whereby a petition under section 144 CPC filed by respondents number 1 to 7 herein has been registered as Miss J case number 292 of 2025.
What is your grievance?
My lord, your lordship will appreciate the antecedents in brief. The petitioner's
No, it
hearing
is
being-
fixed for hearing only.
No, I'll satisfy your lordship. It's fixed for hearing, but it is fixed for hearing parallel to a proceeding initiated at the instance of these respondents number 1 to 7 under order 21 June 97.
But you can take that plea during hearing.
My lord, your lordship kindly sees. Here.
This is an application under
227.
227.
And I am praying for exercising of supervisory jurisdiction of this honorable court in view of the jurisdictional error on the part of the learned court below, because of the fact
But you can take this plea before the trial court.
what happens there
You
is,
have been given an opportunity.
my lord, your lordship kindly appreciates.
This is premature.
Here, I'll just try to satisfy your lordship, my lord. What happens if this proceeding is allowed to carry forward?
No, now only
For this very proceeding. for
what court could have done?
My lord, here, this petition under section 144 is not at all maintainable at the very first, at the stage of limine itself.
You can raise the issue of maintainability on your appearance.
And my lord, thereafter, my lord, in that proceeding, which will be a separate, already that
The-
separate proceeding has been initiated. It is already numbered and registered as Mr. Case 292.
Is there any bar on registration of a miss case under one?
We're trying to, my lord, bring before this honorable court is the fact that already a petition under order 21, rule 97.
No, I understand.
Is by
That petition is there.
that petition
You have filed an order 21 rule
No,
97.
no. We are the plaintiffs. I'll just take your lordship's 2 minutes of your.
No,
lordship,
but
my lord.
prima facie on bare perusal of the order which you have impugned,
My lord,
there appears to be no infirmity.
my lord, I'll just try to satisfy, just, my lord gives me 2 minutes. The petitioners as plaintiffs filed a suit for specific performance of contract, got a decree in the year 2012. Thereafter, through the executing court,
No,
the deed was, yes.
okay, let me hear you.
My lord, the petitioners as plaintiffs got an ex parte decree in the year 2012. In 2013, a sale deed was registered in their favor by the executing court. In 2016,
Decree was for specific performance of
specific
contract.
performance of contract against respondents number 8 and 9 hearing. They are parties here, respondents number 8 and 9, against whom the petitioners got an ex parte decree for specific performance of contract in the year 2012. In 2013, a deed was executed and registered by the executing court in favor of the plaintiffs who were the petitioners hearing. In 2016, through the executing court, possession was handed over to the petitioners who were the plaintiffs
After registration of sale deed.
of the sale deeds through
Okay.
court process.
Okay.
Now, then comes respondents number 1 to 7 as third parties who are not parties in the suit.
Okay.
They come and file a petition under Order 21, Rule 97, 99, and 101 CPC, claiming third party rights. Now, initially, that petition, after appreciation of evidence and on contest, was
How they
dismissed.
can come? You said that already possession was handed over.
They come claiming third party right, my lord, under the provisions of-
After handing over of the
Yes,
possession,
yes. The position.
after complete.
Yes, the handing over of the possession is reflected in the order itself. The writ was executed. The warrant of
When there was no execution proceeding was,
the execution proceeding was closed. Due to pursuant to satisfaction of execution of the decree, there is an order at page number 82. Your lordship will kindly see in that order, it is reflected. At page number 82, if your lordship kindly sees for a while. This is the order, the last order passed in that execution case where the entire sequence of events is very much my lord, pointed out, including the filing of the petition by the respondents number 1. May I read this order, my lord? Order dated 26/9/2018. The decree holder is represented. The third party is also represented. Seen a petition filed by the third party praying to pass necessary order in the instant case. I heard both the sides on petition number 11/581 dated 1960.
okay, what happened to that order 97?
Now that order 21 rule 97 petition is pending. My lord, in between that miss case was dismissed. Thereafter, they preferred a miss appeal. In the miss appeal, there was an order passed to the extent of re-adjudication of the petition under order 21 rule 97. And that order 21 rule 97 petition is
A
pending.
separate miss case has
It's
been.
a miss case number 100 of 2016. Miss case number 100 of 2016. Now, at the stage of argument of that miss case under order 21 rule 97, the same set of respondents hearing who are the applicants in that petition order 21, they have now filed a petition under section 144 CPC, praying for, your lordship kindly says their prayer at 132. They are praying for restitution of possession of the properties already delivered to the plaintiffs in execution of the decree.
Okay.
They are praying for restitution of possession of the property and for compensation. Now, section 144, my lord, it's the clear reading of section 144 is that.
No,
they are-
Mr. Chakravarti,
My lord,
suppose they are not entitled to get restitution.
my lord.
The court has only given you an opportunity to place your case. You place the case before the court, satisfy the court.
My only concern is that it is a parallel multiplicity of proceedings.
You-
Any order,
You can take that plea also.
my lord. Thereafter, an order.
Then
gets-
then only
I
you can
understand.
approach this court.
I
You have
understand.
rushed this court prematurely.
My lord, my humble contention here is that so far that 140 registration of the petition under 144, that ought not to have been done by the court, in which court that petition under order 21 rule 97 is pending. Had it been a different court, things would have been different, but it is the same court before whom that petition under order 21 rule 97 is pending. Without the
No,
decree,
registration cannot be refused.
it cannot be refused.
Ultimately, if the question of maintainability is raised,
My lord.
that may be dismissed on the ground of maintainability. But
True.
registration cannot be refused.
My lord, what happens is,
The court does not seem to be heard on any count.
my lord, kindly take up.
You will withdraw it, or should I dismiss it?
My lord, in that case, I'll have to withdraw with liberty, my lord.
You approach the trial court.
My lord, with liberty, of course, my lord, I'll have.
Yes, heard Mr. D. Chakravarti, learned counsel for the petitioner who seeks who prays for allowing the petitioner to withdraw the instant civil division petition with liberty to file an appropriate application before the Court of Learned Civil Justice Senior Division Kachar in Ms. J case number 292/2025, raising the whereby he may raise the question of maintainability of a parallel proceeding under section 144 of CRPC in view of the fact that between the same parties, a proceeding under Order 21 Rule 97, 99 and 101 is pending before the said court. Considering the submissions made by learned counsel, the prayer is allowed. This case is dismissed on withdrawal with liberty sought for granted.
I'm obliged.
If you apply.
Item 7.
May I please give me the, Lordship, I am the wife of the deceased, Lordship, and I filed a claim petition before MSP with Guwahati, Lordship, and my parents, father and mother of the deceased also filed a claim petition at Dhubri, Lordship. But whether father is not entitled, mother is of course entitled, and by order dated 9/10/25, my claim petition has been transferred to MSCT Dhubri, Lordship. And
On that order you are impugning.
yes, Lordship, I am challenging that order, Lordship, because the MSCT tribunal is having no jurisdiction to transfer. And there was no pleading for transfer of the, simply on the basis of the petition of the insurance company, Lordship, they have transferred the petition, my petition, and they have not transferred, paid for transfer, Lordship. They simply paid for this dismissal of the petition. So this is the challenge, Lordship. Section 24 and 25 of the CPC, Lordship. Honorable High Court is having the jurisdiction to transfer a claim petition from one tribunal to another. And here I am the main legal heir, Lordship. And I was thrown out from my parental house, that my matrimonial house, Lordship. And I am working here in Adabadi, Lordship. And the insurance company also hails from Guwahati only, Lordship, not a Dhubri. So my claim petition should be
Where have you filed your claim petition?
MSC Guwahati, Lordship. I am working in Adabadi, Lordship. That maid servant, home to home, I am working.
Where is the impugn order?
Interview order is in Annexure 1, Lordship. Page number 17, Lordship.
Heard Mr. A.R. Agarwal, learned counsel for the applicant. This application under Article 227 of the Constitution of India has been filed by the applicant, by the petitioner, impugning the order dated 9/10/2025, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, in MEC case number 1597/2024, whereby the state tribunal had transferred this said MEC case to
MSCT Dhubri.
the Motor Accident Claims Tribunal, Dhubri, on the ground that another case arising out of the same accident filed by the father and mother of the deceased
Yes, Lordship.
was earlier filed by was earlier filed before the
No, Lordship, that case was subsequent. My case is. earlier.
was filed, was pending. Is pending before the Motor Accident Claims Tribunal, Hubli. Learned counsel for the petition. Petitioner submits that the petitioner is presently residing and earning her livelihood as a maid servant in Guwahati, and the respondent insurance company also has its office in Guwahati,
Accident also occurred in Saigon, Lordship.
and the accident in question also occurred within the jurisdiction within Kamrup district. Therefore, he further submit within Kamrup district. He further submits that the MAC case number 54/2024 was filed after filing of the MAC case number 1597/2024 by the present petitioner. Hence, the learned member Motor Accident Claims Tribunal number 3 has erred in passing the impugn order. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order, returnable on 16th of December. Let this
Interim order.
let the scan copy of records of MAC case number 1597/2024 be called for from the concerned Motor Accident Claims Tribunal. Stop. In the meanwhile, considering the submissions made by London counsel for the petitioner as discussed in the foregoing paragraphs, the operation of the impugn order shall remain stayed till the next returnable date, list according.
Item 9.
May it please your lordship. My lord, the present appeal has been filed under section 23 of the Railway Claims Tribunal Act. My lord, herein the learned Railway Claims Tribunal at the time of execution has went beyond the decree and has not granted interest to the petitioner, appropriate interest to the appellant. That's why the appeal has been filed.
You were granted, your claim was allowed,
Yes, ma'am.
only interest has not
Only
been.
interest part was not allowed. 6% interest was allowed. However, in the original order, it was supposed to be 9%.
Okay. Heard Mr. D. Rathi, learned counsel for the appellant. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been filed. This order is passed where has been filed by the appellant challenging the order dated. Is this an appealable order?
Yes, ma'am. Under 23.
Has been filed by the appellant impugning the order dated 16/9/2025 passed by the Railway Claims Tribunal, Guwahati bench in execution application number EXA/GHY/011/2024 arising out of original application Roman 1-1216/2007. The main grievance of the appellant in this appeal is that while executing the decree of the trial court, while executing the judgment and decree of the trial court, the executing court did not abide by the judgment and paid less interest than what was directed to be paid as per the judgment of the trial court. Issue notice to the, no notice you have served.
Extra copy has been served to CPC. That will be it.
Since the petitioner has already taken steps, has already served notice on the learned Central Government Council, who is appearing Central Government Council for the respondents. No formal notice need to be issued to the respondent. Let the records of the execution application as well as original application mentioned herein before be called for from the Railway Claims Tribunal, the registry to take steps for requisitioning the records. Let this matter be listed after 4 weeks on receipt of the aforesaid records.
Much obliged.
Item 10.
I will plead your lordship. Lordship, it is a statutory appeal under section 23 of the Railway Claims Tribunal Act 1987 against the rebuke judgment and order dated
What is your name?
M. Kolita.
Heard Miss M. Kolita, learned counsel for the petitioner. Appellant. Also heard Mr. B. Chakravarti, learned
CGC.
Central Government Council appearing for the respondent. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellant, impugning the judgment and order dated 22/8/2025 passed in the original application number OA 3 Roman 3-103/2015 by the Railway Claims Tribunal Guwahati bench. Stop. This issue notice. Since Mr. Chakravarti has already appeared for all the respondents, no formal notice need to be issued to the respondents.
Extra copies may be served. Lordship.
The petitioner, the appellant is directed to furnish extra copies of the memo of appeal along with the annexures to the learned Central Government Council appearing for the respondent during the course of the day. Let the records of original application mentioned herein before be called for from the Railway Claims Tribunal. List this matter after receipt of the aforesaid records.
Item 11.
Wait, please, my lord. When I'm preferring this present regular first appeal on being aggrieved by the order dated 14/5/2025, my lord, passed by the Appeal Judge Senior Division Jorhat, my lord, entitled suit number 50/2024, my lord. At this juncture, I pray that notice may be issued and the lower court record may be called for, my lord.
Heard Mr. G. Kaushik,
R. Censor.
sorry. R. Sinchwa, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure 1908 has been preferred by the appellant Shri Nilambar Gogoi, impugning the judgment and decree dated 30/5/2025 passed by the Court of London Civil Judge Senior Division, Jorhat, in title suit number 50/2024. You were the plaintiff,
Was the plaintiff. Has been passed.
dismissed, whereby the suit of the plaintiff, present appellant was dismissed. Issue notice to the respondents and call for the records of the trial court. This appeal is admitted. The appellant shall take steps for issuance of notice upon the respondents by speed post within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Make to the justice. This is the first appeal. Filed under order 43 rule 1R. Impugning the order dated 12/8/2025. Passed by the Learned Civil Judge District, granting temporary injunction to the respondent who has filed their suit for declaration and permanent injunction, claiming that they have purchased the suit land by way of sale deed from the respondents. My lord,
Will issue notice. Heard Mr. R. K. Jain, learned counsel for the appellant. This appeal under order 43 rule 1 within bracket small r of the Code of Civil Procedure, 1908 has been preferred by the appellant Shri Krishnandu Saha, impugning the order dated 12/8/2025 passed by the Court of Learned Civil Judge, Senior Division Dhubri, in Ms. J case number 74/2018 in connection with title suit number 41/2018, whereby the respondents were granted relief of temporary injunction against the present appellant by the trial court. Issue notice to the respondent. The petitioners shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 18th of December.
I had some personal difficulty.
4 weeks.
I had some family problem. Let it be first week of January if possible.
Oh, okay. Returnable in the January calendar as in. Returnable on 6th of January 2026. List accordingly.
Under order 41, item 13.
May it please your lordship.
Yes.
My lord, this is a defendant's appeal. Second appeal. Suit was allowed, appeal was dismissed as against this, second appeal was fine. We are only on a very core issue. If my lord would have the plaint at page 75.
Suit was for?
Declaration of right title interest, correction of record, confirmation of possession, and permanent injunction.
Confirmation of possession.
I have not on that. 75 is the plaint, it starts. And the prayer would my lord would have at page 77 for a minute. Prayer. The suit was registered as title suit 51 of 2011. Paragraph 14. My lord is there.
Yes.
First, it's they seek a decree for declaration. Second, decree of declaration. Third, declaration. Then mandatory injunction, etc. Whatever be the reason, I invite my lord's attention to page 76, the core paragraph of the plaint. Paragraph 5. We are defendant numbers 1, 2, 3, and 4. Paragraph number 5. May I read, Milo?
Yes.
That the defendant number 8 in collaboration and in connivance with defendant numbers 1, 2, and 3, that's government, fraudulently got correction of land measuring 2 kathas 10 lechas out of land of B scheduled land without right title interest and possession on the land and unlawfully included the said land in DAG number 2170/102 and one Hamidul Islam, defendant number 5, filed a petition of 8th of December 2003 for correction of records in the name of defendant numbers 4 to 7, that's us, being miscase number 14/04, in which case false, fabricated, and motivated reports were collected, and defendant numbers 4 to 7 collusively, in connivance with defendant numbers 1, 2, 3, procured an order on 26/5/2005. That's very essential, 26/5/2005 from the defendant number 3 for cancellation of the royalty khatiyan of the plaintiffs and got correction their names in the record on 2/6/2005, violating the provisions of land revenue, so and so. The defendants 4 to 8 unlawfully corrected record in their names has clouded the title of the plaintiffs in respect of the B scheduled land. In essence, my lord, it is challenged to a 2005 order of cancellation, which my lord finds and the prayer B and C. Prayer number C. A decree of declaration that defendant number 2 has no authority to cancel. I'm correlating with that thing. Am I clear? Could I?
Yes, yes.
Now, the cause of action, paragraph 12. Cause of action arose on 26/5/2005. That's the cancellation, Milo. Paragraph 12. My lord would have it with paragraph 5.
Yes.
And then 2/6/2005. That's the correction effected, physical affection. That's also in paragraph 5.
Yes.
So this is basically what the suit was for. Now, whatever be our defense, we said one thing at page 79 in the WS. We said that they had earlier instituted a suit, but had withdrawn it with a liberty to file a suit afresh in 2010. May I invite my lord's attention to page 79.
Yes.
Paragraph 4. That the suit is barred by res judicata. I'm not on that for the moment. Earlier suit being title suit number 365 of 2005. Lordship kindly considers this is 2005. Instituted by plaintiff numbers 1, 2, 3, 4, and 5 sought the following reliefs. Number 1, that's same with the present relief. Decree for declaration of plaintiffs have right title interest, confirmation of possession of the land described in Schedule B as per Royalty Khatiyan. B. For a decree of declaration that the defendant number 6 has no legal authority to cancel the Royalty Khatiyan, that's already now in the main prayer. That's 2/6/2005.
Yes.
So 2/6/2005, they challenged correctly in the title suit 356 of 2005. Now, this was allowed to be withdrawn with liberty, and thereafter this present suit was filed. There's no difficulty that the liberty was granted to withdraw.
Yes.
Now, would my not have the limitation act and the CPC for a moment, what I'm trying to address on a substantial question of law. Order 23, I'll come to that, the provision. Order 23 of CPC Lordship
Yes.
is there.
Yes,
I would invite my Lord's attention to Rule 2. May I read below?
yes,
Limitation law not affected by first suit. In any fresh suit instituted on permission granted under the last preceding rule, the plaintiff shall be bound by the law of limitation in the same manner as if the first suit has not been instituted. Meaning thereby, if I may submit, with all respect, when the 2005 suit was allowed to be withdrawn with liberty under Order 23 in 2010, it did not override the provision of Article 58 of the Limitation Act because it was a declaratory suit.
what is the limitation?
3 years.
3 years.
And when the right to sue first accrues, admittedly 2005 it accrues. That's the cause of action. That's the prayer. Therefore, how did both the courts err in this? The trial court frames the issue. Issue number 8 at page 52. 8 issues were framed. This is the third issue, Miller, on limitation. The issues at page 52. Trial court issues at page 52, Miller.
Yes,
Number 3, whether the suit is barred by law of limitation. Now, discussion to that would be at page 54. Paragraph 13. I presume I'm trying to.
yes,
May I? The contesting defendants had made a claim that the instant suit is barred by law of limitation on account of the fact that the plaintiffs had earlier filed title suit 356 of 2005 against them regarding the same subject matter and seeking the same reliefs. The plaintiffs had withdrawn the earlier suit on 11/6/2009 with a leave from the court to institute a fresh suit, but could not file the instant suit within the period of limitation. On consideration, it is seen that both the sides are in agreement that the plaintiffs had earlier filed the aforesaid suit, but had withdrawn the same with a leave to institute a fresh suit. The contesting defendants had alleged that the plaintiffs did not deposit the cost of so-and-so, which only imposed for a moment. Well, if I may skip for a moment, paragraph 14 would give the answers. That's a recital. Paragraph 14, Lordship, is there.
yes,
Now, since the instant suit seeks declaratory reliefs, the law of limitation prescribed under the Limitation Act 1963 would be 3 years, starting from the date of accrual of cause of action. If one considers aforesaid date to be 2010, this is the error. Here comes the perversity, and the appreciation of that falling would be error apparent. As and when title and possession of the plaintiffs was threatened, the instant suit being filed on 1/11 was filed very much within the prescribed period of limitation. Herein, the composite understanding of the Article 58 read with 23(2) or the 23 Rule 2. Herein, the learned trial court, in my most respectful submission, committed error in law based on facts. Because 23(2) does not give a fresh limitation. It affirms the original cause of action to be the limitation. Now, how did the appellate court appreciate it? Appellate court, while framing the points for determination, at page 30,
when they came to
my lordship,
know about the rectification of records.
everyone knew that 2005, so they filed in 2005. The suit was instituted 2005.
Okay.
And the cause of action remains. What I am trying to submit before your lordship is that this is a defendant's second appeal. This point of law was neither addressed nor appreciated in the perspective of a conjunctive reading of Order 23 Rule 2 and Article 58 declaratory suit reliefs, how it comes along.
How the appellate court dealt with
Appellate
this?
court dealt with it. I would invite my lord's attention to page 25, paragraph 13, how the appellate court dealt with it. They framed the points for determination at page 24. That page 25. Paragraph 13.
Yes,
Paragraph 15 would be correct, 15 would be more detailed. May I read?
Yes.
The perusal of the impugned judgment reveals that the learned trial court discussed this issue in details and observed that the suit was filed within limitation and thus maintainable. Learned trial court observed that a suit on different cause of action is not barred, although suit relates to the same property. Learned court below further observed that since title suit 39 of 16, that's renumbered below, 51 of 11 actually, seeks declaratory relief, so the period of limitation as per Limitation Act 63 would be 3 years from the date of acquittal of cause of action. And if one considers the date in the year 2010, as and when the title and possession of the plaintiff were threatened, the instant suit being filed of 1 to 11 was filed within limitation, my lordships. Herein comes the error in appreciation.
So out of the three reliefs,
Yes, I'll correlate now, 77 for a moment. Page 77 for a moment.
out of the three reliefs, one relief was barred by the limits.
See, if C is barred, then nothing goes to them. Of course, for trial court to see, if the cancellation of the Rayati Khatiyan goes by operation of law, then A, B, D, nothing, mandatory injunction out of the way. So far as declaration of right title plaintiff cannot, unless the Khatiyan goes,
Where is your memo of appeal?
my lordship.
Where is the,
I'm coming to that, page 5. So there was no jurisdiction so vested because it was barred. A. Whether a new suit filed with additional cause of action after withdrawal of an earlier suit extends the period of limitation for the new suit where some the relief sought for is barred by limitation. Or, if I may pray, my lord, lordship may also pray whether the suit was barred in a conjunctive reading of Order 23, Rule 2, read with Article 58. I did not put it so specifically. I was expecting someone to be on caveat.
okay.
That is the core issue. We are in possession.
So only who is in possession?
We are in possession.
It was a suit for confirmation of possession.
But we continue to be there. Therefore, we have filed an IA also for stay of this.
No, the relief.
I understand what lordship is saying.
They are not seeking recovery of
They are not
possession.
seeking recovery of question, but that they would dispute in the point of time. On the pleadings front, they are not seeking that. But I'm not even.
Then there is no.
I understand that, but I'm not even assailing on that count. I want to block them in the first time. Let them come up with that later. When they come up, respond to that.
No, what do you want to stay?
The operation of the judgment.
Operation cannot be stayed. The execution has.
Execution.
Is there any execution proceeding?
I do not know as of now.
So we'll issue notice. Your prima facie, there appears to be some force. So we will frame issue only point. Only A.
A and D, because both the courts below, with all respect, had traversed to a point of 2010 without traveling prior point of time to 2005 to appreciate the correlation.
Heard Mr. L. Bani.
S. Bani.
Sorry. L. Bani, S. Bani. Learned counsel for the appellant. This regular second appeal under section 100 of the CPC, 100 of the Code of Civil Procedure, 1908, has been preferred by the
Defendant numbers 4 to 7.
Preferred by the appellants who were the defendant number 4 to 7 in the original title suit number 39/2016, impugning the judgment and decree dated 3/6/2025, passed by the Court of Learned Civil Judge Senior Division, South Salmara Mankachar, whereby the title appeal number 3/2021, which was preferred by the present appellant, was dismissed, and the judgment and decree dated 27/11/2020, passed by Learned Court of Learned Civil Judge Junior Division, Hatsingimari, in title suit number 39/2016 was upheld. After going through the memo of appeal as well as other documents annexed therewith, and after considering the submissions made by learned counsel for the appellant, following substantial question of law is formulated in this regular second appeal with an inverted comma. Whether the we can formulate it in the general
Yes, I understand. I
without,
promise you that.
without specifying
Understand. That-
whether a new suit filed with additional cause of action after withdrawal of the earlier suit extends the period of limitation for the new suit, where some relief sought for is barred by limitation. And number two, whether the trial court as well as first appellate court came to a perverse finding on the issue of limitation to the extent it ignored the applicability of
Order 23, Rule 2,
Order 23, Rule 2,
CPC,
CPC,
read with Article 58.
read with Article 58 of the Limitation Act. In holding that the title suit number 39/2016 is not barred by limitation. This much will do. Though the respondent as plaintiffs had filed an earlier suit, that is title suit number
356 of 2005.
356 of 2005, also seeking relief of declaration, and which was allowed to be withdrawn
With liberty.
with liberty to file,
11/6/2009.
with liberty to file a fresh suit by order dated
6/2009.
11/6/2009. And to পঢ়ি দিয়কচোন second issue. No, second issue from the start. I'll rectify where is in where.
Well, so far as the observations is paragraph 32 of the judgment below. Unless there is a stay 41 Rule 5, this still holds the field.
Para
page 70, page 32. Once the second appeal is admitted, may not, 32 cannot hold the field. My most respectful submission. Page 70. May I read my lordship is there?
Yes, which
In
portion?
view of 32 paragraph 870.
Yes,
In view of the above discussion and the decisions on the issues aforesaid, the instant suit is decreed with contest with costs. It is hereby declared that the plaintiffs have right title interest over the suit land described in the Schedule B of the plain. Their possession over the Schedule B is hereby confirmed. It is further declared that the cancellation of Rayati Khatian, which had been issued in the name of their predecessor Hiralal Sharma, and the incidental correction of records in the names of defendant numbers 4 to 7 appears to be unlawful, collusive, and liable to be cancelled. The defendant number 1 to 3 are directed to effect necessary alterations in the records of rights so as to include the names of the plaintiffs over the suit land in capacity of riots. They are further directed to demarcate the suit patta as to identify the land originally included in actual Khatian number 288. The event numbers 4 to 7, their agents, servants, representatives, or men are hereby restrained from entering the suit land or from interfering with the peaceful possession of the plaintiffs in any manner. The corresponding, may not the ministerial activities would follow of this declaration. Since my lord was pleased to admit the second appeal, my lord, I pray that the 41-5, the operation, that execution be stayed. This would have a corresponding letter. What do you say? Oh, numbers on the line, where are they?
yeah, I issue notice to the respondents. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post. It will automate, whether it has been done,
My lordships.
no execution
I
cases.
know, but since the order is there.
ফোন করেছিলে? ও
I don't-
ঠিক আছে, হ্যাঁ, ওকে।
LA appeal number 18/2005 also. The notice are served on the respondent. Since the aforesaid LA appeals are analogous in matter, are analogous in nature and taken up together. And since service on respondent in some of the appeals are yet to be completed, registry is directed to place this matter before Lawajima Court to verify as to whether notices to effect due service of notice upon the respondents to verify continue to verify due service of notices upon the respondents. Only after due services of notice on the respondents, this matter may be placed before the regular court. List accordingly. I'll make some corrections. List accordingly. Let the service be complete.
Plus, there is my substitute also, my lord. They have to substitute their legal years of the, this is respondent, my lord.
After legal years names, I could not find out lordship, but I personally went to the that village, but nobody knows.
No, let it, otherwise it will go on and on.
Pub.
For last 20 years,
This is very well.
you are unable to.
I want to find an IA lordship for publishing, paper publication. Otherwise, not.
No, you take all this, please, before the Lajima Court.
Much.
Public.
26.
Wait, please, Lordship, this case is pending. I filed this case by the insurance company last 10 years, my lord. Service is complete. So they also appeared, claimant, reference number 1 of the appeal. Name is shown in the advertisement. So maybe fixed for my lord hearing, as in as it is a case of 2015.
Notices, service is complete on respondent number 2.
But
You have not gone through the office note. Notice to respondent number 2.
go through this record, my lord, then for the time.
Huh?
I go to the record for the time.
No, I am going through the office note. You have to take fresh steps on respondent number 2.
Well, I took lot of number of time as a test with the owner.
No, you take fresh steps, then we'll call for the postal track consignment report.
So automatically come to the registry, madam.
We'll call from the registry. You are insurance company.
Right.
Heard Mr. R.C. Paul, learned counsel for the
Go to yes, I'll take the step.
appellant on perusal of the office note dated 7/11/2025, it appears that notice is sent to respondent number 2 through registered post has not yet been received back. So in view of above, the appellant is directed to take fresh steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order.
The usual process I'll take.
By speed post as well as by usual mode. Speed post.
As well as usual process.
Why usual?
Usual process, my lord, sometime.
Speed post as well as by usual mode. Within 7 days from the date of this order. Returnable on 18th of December. List accordingly.
Yeah.
7.
May it, Mr. Lordship, my lord, here I need some time to take instruction from the client, my lord. Here the earlier conducting counsel, our messenger has been elevated to the bench. I need instruction from the client.
What instructions?
My lord, here I haven't even filed my Wakal as well.
This case is was pending long 2019. I filed in my Okalat number 2023. 19 appeal was filed by the claimant.
No, you have to take steps for each.
On the day of motion, my lord, only respondent notice was issued upon respondent number 3
So
only. At that
this
point in
appeal
time.
is for my lord, this appeal is for NS.
You are appearing for respondent number 3 also.
Yes, my lord.
Okay.
But for enhancement, my lord. That is why I think 1 and 2 may not be required. Because it is the award is 5,000 only, because they could not prove. So far I have gone through the judgment. They could not prove the discharge certificate as well as the vouchers and others, lot of things. So it is the clear-cut findings of the learned trial court. So they come for enhancement. So I think
Now, what is the submission?
My lord, here, since the conducting counsel has been elevated to the bench, I have no instruction to the client. I need 2 weeks time at least to get instruction
that
from
may
the
be
client.
fixed
Oh,
because it is a case of 19.
Okay. Heard, miss, what is your name?
Iwa Pangla.
D. Wapanga, learned counsel for the appellant, who submits that as the earlier engaged counsel has been elevated to the bench, she needs some time to take instructions from the appellant regarding continuation of this appeal by the you are there, your Wakalatnama.
My Wakal is not there.
Okay. Regarding engagement of a new sets of counsel, the prayer is allowed. Let this matter be listed.
My appearance is
Also, Mr. R.C. Paul.
that's one number 3.
Appearing for respondent number 3. Let this matter be listed. When? How much time? After 2 weeks.
My lord, 2 weeks.
Date,
Ah.
date only. If
18th of December.
8th of December.
18th of December.
My lord, oblige.
Okay.
May I please, Your Lordship? My lord, this is an appeal for enhancement. 50%, 2 insurance companies are involved. My lord, both the insurance company have entered appearance. Sir, other respondent lordship may not be necessary party. They are the driver and owner. Your lordship may stack down their names, respondent number 3, 4, and 5. And matter may be lordship posted for hearing because the 2019 matter, CCR has already been seen.
Yes, you have any submission?
No, Lordship. I am appearing for respondent number 2.
Heard Mr. M. Khan, learned counsel for the appellant. Also heard Mr. S.P. Sharma appearing for respondent number 2. Learned counsel for the petitioner has submitted, appellant has submitted that this appeal has been directed against the impugned judgment of the Motor Accident Claims Tribunal, mainly seeking an enhancement of the compensation awarded to the appellant / claimant. Hence, he submits that the presence of respondent number 3 and 5 may not be
3,
necessary.
4,
3?
4 already received, but they have not. appeared.
3 and 5 may not be necessary. Hence, notice to them may be waived. The learned counsel for respondent number 2 does not raise any objection. The prayer is accordingly allowed. Since the records from the concerned motor accident claims tribunal have already been received, this appeal may be heard. This appeal is ready for hearing. Accordingly, let this appeal be listed for hearing after 4 weeks, 6 weeks.
Waiting for a date, Lordship.
No. After 4 weeks on a date to be fixed by registry.
Obliged.
Lordship, here in this case, inadvertently, Lordship, we could take steps only yesterday, Lordship. Upon respond number 2 and 3.
Heard Mr. S.P. Sharma, learned counsel for the petitioner. Also heard Mr.
R. Patwari, respondent number 1.
R. Patwari appearing for respondent number
R.
1.
Patwari, Lordship.
R. Pathor appearing for respondent number 1. Learned counsel for the appellant has submitted that the appellant has taken steps for issuance of notice upon respondent number 2 and 3 only yesterday, and therefore service report may be awaited for some time. Considering the submissions made by learned counsel for the appellant, let this matter be listed after 4 weeks.
Deeply obliged.
Wait, please, Lordship. Here in this case, Lordship, record was called for in the year 22. Till date, not received.
Why? Heard Mr. M. Talukdar, learned counsel for the appellant.
Lordship, I am appearing for respondent number 3.
Also heard Ms.
P. Botha.
P. Bhattakur appearing for respondent number 3. It appears from the office note dated 14/11/2025 that records of MSC case number 671/2015 has not yet been received from the Motor Accident Claims Tribunal Kachar at Silchar. It also appears that requisition for the same was made by the registry of this court way back in the year 2022. Way back in the year 2023.
Lordship, record was called for from
10/7/2023.
Kamrup Metro.
Why Kamrup Metro? Case is pending.
From Kamrup Metro.
But the impugn judgment was passed by the which tribunal? Kamrup Metro. But in your synopsis, you have mentioned, where?
Lordship, Rashmi can see the cost title. Yeah.
It has to be from Kamrup Metro.
MSCT two loss.
Agol line to correct call. Kili. Agol line. From which port? Kachar Silchar building. MSCT. MSCT.
At place 7 lordship. MSCT 2 Kamrup Metro.
MSCT number 2 Kamrup Metro. The registry to issue fresh reminder for the same with an intimation to the concerned motor accident tribunal to positively remit the record without fail before the next date fixed. Let this matter be listed again on 18th of December.
Obliged.
Obliged.
Item 41.
May it please your lordship. Your lordship, in this case, respondent number 1 to 3 has already entered appearance.
So this is ready for hearing.
Lordship, but as regards respondent number 4, your lordship may peruse office note dated 11/11/25. Your AD card has not been received, your lordship, in respect of respondent number 4. Your lordship, respondent number 4 is the owner cum rider, and we have challenged the quantum of compensation, your lordship. So his presence may not be required, your lordship.
Yes. Heard Miss P. Bhattakur, learned counsel for the appellant. Also heard Mr. M. Talukdar, learned counsel for respondent number 1, 2, and 3. On perusal of office note dated
11/11/2025.
11/11/2025. It appears that the notices issued to respondent number 4 has not yet been received back. Learned counsel for the petition appellant submits that the instant appeal has been preferred by the insurance company appellant, mainly challenging the quantum of the compensation awarded to the respondent claimant, and therefore submits that since the respondent number 4 is the driver, owner cum rider, his presence may not be necessary for consideration of the instant appeal, and accordingly prays for waiving the notice to respondent number 4. The learned counsel for respondent number 1, 2, and 3 does not oppose the prayer. Hence, the prayer is allowed. The notice to respondent number 1 to respondent number 4 is accordingly waived. Since
LCR has been received, your
since the records of concerned MSC case has already been received, this case is ready, this appeal is ready for hearing. Accordingly, list it for hearing after 4 weeks on a date to be fixed by registry.
Okay.
42. May it please your lordship. Item 32 and item 46 my lord, arises out of the same judgment, my lord. 46 lordship. And in item 32, lordship may kindly peruse office note dated 11/11/2025, my lord.
Yes.
Office note dated 11/11/25, my lord. R1 received, R2 received by wife, my lord. So service is complete.
RC is appearing in the matter?
And in
46 lordship. In 46, they have filed the appeal, my lord.
okay.
My lord,
In-
in item number 46, we have filed.
No,
a-
we'll take it up. We'll pass separate orders.
Sir.
Heard Mr. A. Lal, learned counsel for the appellant. Also heard Mr. A. J. Sakya, appearing for respondent number 3. It appears from office note dated 11/11/25 that notices issued to respondent number 1 and 2 have been duly served. Accordingly, said notices are held to be duly served on the aforesaid respondent, on the said respondents. The service of notice upon all the parties is complete. The trial court, the records of concerned MEC case has already been received. Hence, this appeal is ready for hearing. Stop registry to list this matter for hearing after 4 weeks on a date to be fixed by registry. 46 now. What is this I for?
My lord, I is for vacating the stay order, my lord. They have got a stay, my lord, on 19/12/2023. Since then, my lord, this is stay. So we pray, my lord, that the I be taken up, my lord, on a date.
Along with the,
My lord, in the
it
next
can be
week, lord,
disposed of
It
on
can be disposed of, my lord,
the,
because it has to be taken up for the I has to be, because they cannot keep on staying, enjoying the stay order, my lord. For 2 years, they have been enjoying, and if lordship.
now let us see if in the next date matter is, now matter has been
Lord,
fixed for final hearing.
2015 matters also, my lord, MSc appeals are pending, my lord. And if this is also kept pending, my lord, will go for 10 another years. The difficulty is, my lord.
Where is your appeal? 40 some?
46. So it has to come in a stay vacating column, my lord. And if on that, both the appeal can be disposed of, it is well and good, my lord. We have no objection to that.
Lordship, we have already deposited 50% of the awarded amount, Lordship. As per.
No, their objection is regarding stay. If you have no objection for their taking 50% of the awarded amount, you receive 50%.
We have,
You have received.
we have received.
Yeah, does not
Other
arise
50%
in
they
violation
stayed,
of-
my lord. And
That is subject to the decision of the appeal.
Yes, sir.
If, my lord, the difficulty is, my lord, the tribunal award compensation interest part at 6%. They enjoy my money, they earn more than that, they keep it pending, my lord. This is the policy of the insurance company that keeps on going on, my lord. In any small
They
issue.
don't pay the additional interest you are not getting.
That's it.
Interest during this,
Interest is so low, my lord, does not even match the inflation value, my lord.
okay. And the interest which accrues during the stay period,
That is 6%. That is a difficulty. And for that, all these appeals are coming. If your lordship takes up the appeal, my lord, they don't have any case. We have exhibited the salary certificate, we have exhibited, my lord, the appointment letter. Thereafter, there is a judgment of the tribunal. Thereafter, they have put it to challenge. And because it's a statutory appeal, the moment the appeal is filed, the matter is stayed. That becomes a difficulty. Now, 2017 accident, lordship. One daughter has committed suicide after the accident, lord. Now only the mother is surviving. So all these problems comes up in MSc cases, lord. So I pray maybe my stay vacating petition be taken up on a fixed date, lordship, as lordship pleases, my lord. But on the stay vacating column, lordship.
Okay, matter is to be heard in at length, Lordship. It is already ready for.
And that too,
Agor
what cases, my lord, how, what
commanded.
length, my lord?
Agor case date. 4 weeks let this Agor case, let this matter be listed in hearing column on 6th of January.
Not in hearing column, it will come in the
No,
orders. place, stay
earlier
vacating
matter,
column. Lordship.
earlier matter on
Earlier
6th
matter,
of January.
hearing, it will go for hearing, my lord, but let both the matter come together. my lord.
Along with MSc case number 458/2023. In MSc case number 458/2023. Heard Mr. A.J. Sarkar, learned counsel for the appellant. Also heard Mr. A. Lal, learned the additional public prosecutor. What is, we have,
Lordship, in Article 46 of his service on 1 and 2 is maybe deemed lordship, deemed complete lordship. We have taken state lordship, but they, it is shown that it is awaited. In other case, they have received. And in same address, we have sent notice, but it has not returned back. Lordship. So presumption of service may be drawn, lordship, in the future.
And we will be the principal party also in the matter.
on perusal of the office note dated 23/4/2025. 23/4. 23/4/2025. No, continue. It appears that registry has not put up an up-to-date office note, and the office note which is available is only of 23/4/2025. The registry is directed to place an up-to-date office note in respect of service of notice on the respondents. Place this matter along with MSC case number 422/2023 on 6th of January.
Lordship, in the I, there has to be an order, my lord.
I,
It has to come in the stay vacating column, lord. The petition for stay vacating.
this application, this application, this interlocutory application has been filed by the applicant slash claimant slash respondent in connection with MSC case number 458/2023, impugning the, praying for vacating the stay of execution of order dated, which is the order
19/12/2023, page 25,
19/12/2025,
2023. 3 million, not 5, 2023.
2020. No, by this order stay was granted,
By this order, stay was granted 19/12/2023.
vacating the stay order dated 19/12/2023, passed in IA within brackets civil number 3789/2023 by this court. Mr. A.J. Sarkar. Who are the opposite party?
My lord, the insurance will be the primary opposite, but they have obtained the stay, my lord. Other honor driver will be there, my lord.
The Mr. A.J. Sarkar is present on for opposite party number 3 insurance company. Since this stay is directed against, since this interlocutory application is directed against the stay granted by this court on an application by the respondent number 3, at this stage, notice to respondent number 1 and 2 does not seem to be necessary for adjudication of this interlocutory application. Hence, the notice to them is waived at this stage. This matter shall be heard on the next date. That is on 6th of January.
Only preliminary, it should come industry vacating column, my lord.
Now, wherever it comes,
It will not reach, my lord. The difficulty is that, my lord, if it comes so down the bottom of the list, my lord, will not reach.
then
My lord,
that is the difficulty.
No, the
When
rule-
one of the case is fixed for final hearing and both cases are tagged analogously, we cannot keep
but on
the main matter kept
when
waiting
there
for
is-
an interlocutory.
Lordship, my lord, my submission is. my
On
lord,
that day, you can pray for, we have reflected that it has to be heard. Least according.
6th of January. I'm obliged.
Item 43.
That's it. Kindly pass out for time. Can you please accept it to Lordship? And this on he's on list.
What is the matter?
It's time for condemnation of delay. Delay. Condemnation of delay.
Condemnation of delay. You have a,
I don't,
okay,
I don't possess the instruction. Lordship.
okay, let him come.
That's okay.
Item 44. Any time for the appellant Miller and appeal Miller for adjustment of Miller the amount. And notice of issued Miller and respondent has appeared. Not all are sought Miller. So my prayer, LC also received Miller. So my prayer it may be step for hearing Miller, then I need it.
Heard Mr. A. Rashid, learned counsel for the appellant, also heard Mr. A. J. Sakya, appearing for respondent number 3. It is submitted at bar. Notice has been served.
My lord, their name has been listed, 1 and 2, their name has been shown, advocates. Because this is.
It is submitted here by learned counsel for the appellant that but there is no office note
But Miller, all these Miller have seen their names, all the names in the respondent.
that who is appearing for respondent number 3
So 3 is my land paper, I am for appellant 3.
that
In principle.
no that for respondent number 1 and 2 has been duly represented by the engaged counsel as Wakalatnama has been filed by them as reflects from office note dated 14/11/2025. The records of the concerned MEC case has also been received. Hence, this case is ready for hearing. Release this matter for hearing after 4 weeks. What is the matter?
Delay condemnation application.
We'll take it up after some time. Let him come.
Item 45.
May I please your lordship? As per the office note dated 15/11 and already appeared for respondent number 1 and 2. That I may fix for mission hearing.
Matter may be fixed for hearing.
Service is complete.
Upcoming,
Okay.
I have entered appearance.
Heard Mr. What is your name?
R.K. Mohanton.
R.K. Mohanto, learned counsel for the appellant. Also heard Mr. D.P. Sodhi, learned senior counsel assisted by Miss M. Roy, learned counsel for all the respondents. All the respondents. Since the appearance of parties are complete in this case, let this matter be listed for admission hearing. Admission hearing after 2 weeks on a date to be fixed by registry.
If there is a injunction matter, so kindly date may be fixed.
Suggested it after 2 weeks. Putul. Putul.
2 weeks.
10th
Yes,
of,
yes, sir.
10th of December. This,
Alright,
this,
fine.
Isn't it? Application for condonation of delay of 35 days in preparing the MSc appeal.
Well, I have no objection regarding 35 days of delay.
Mr. A. Bhattacharya, learned counsel for the applicant. Also
And Devnath Lordship.
heard Mr. M. Devnath, learned counsel for
Claimant respondent number 1, 2, 3.
respondent / claimant number 1, 2, and 3. This application under Section 5 of the Limitation Act 1963 has been preferred by the applicant insurance company, praying for condonation of delay of 35 days in preferring the connected MAC appeal, whereby the judgment and award dated 9/4/2024 passed in MSc case number 442/2022 by the Motor Accident Claims Tribunal number 2, Kamrup Metro Guwahati, has been impugned. Learned counsel for the respondents submits that since the delay is only of 35 days, he does not have any objection for condoning the same. If objection if this same is condoned. So, I have considered the submissions made by learned counsel for both sides and have gone through the reason grounds stated in the application for condonation of delay or delay. Grounds stated in the application for condonation of delay. Stop. Considering the grounds mentioned in the paragraph number
4 to 7.
4 to 7 of the delay condonation application, as well as also considering the fact that the respondent number 1 to 3 have no objection to the same. The delay of 35 days in preferring the connected MAC appeal is hereby condoned, and this interlocutory application is disposed of. The registry is directed to register the connected MSc appeal and list the same for admission on a date to be fixed by it.
Oblige.
Oblige, Your Honor.
47. May I please your lordship? My lord, that PCR is called for, my lord, earlier occasion. But my lord, may kindly peruse the office note dated 17/10/2025. This flag.
It has not arrived.
Original record has not been traced out.
Could not be traced out. Oh. What is to be done? Let us give some time.
Yes.
Heard Mr. S.M. Borua, learned counsel for the petitioner, Learned Counsel for the appellant, testamentary appeal. Learned Counsel for the appellant. Also heard Mr. D. Talukdar, Learned Counsel for the respondent. On perusal of the office note dated 17/10/2025, it appears that the trial court is yet to trace out the records of probate title case number 17/21 in connection with testamentary appeal number 6/2025, and hence some time has been prayed. So in view of the office note, let a reminder be issued to the trial court, to the Court of Learned, Additional District Judge FTC number 3, for requisitioning the aforesaid records. Let this matter be listed.
20th January, my lord.
No fixed date. After 6 weeks, or you want a fixed date?
Let me fix on 20th January.
20th
January.
January.
Well, I shall be out of station.
Okay, 20th January.
Okay. Item 48.
My lord, this is a transfer petition, my lord. The respondent husband have instituted a divorce proceedings before the family court at Guwahati. The petitioner herein, she is from Dibrugarh. 2 cases are already there at Dibrugarh, one maintenance and one under Domestic Violence Act. 2 are there. One is
You have filed objection.
Sure, yeah, filed it.
You
I
have-
have filed your objection, my lord. I'll take your lordship to their objection also. So, my lord, both the husband and wife, my lord, they were staying at US.
Your husband
I am the wife.
or your wife,
Husband filed the divorce application
where?
before the family court, Guwahati. Kamrup Metro, Guwahati, my lord.
Okay,
And wife filed 2 proceedings at Dibrugarh, one domestic violence and another maintenance. So, my
Right.
lord, there are 3 sets of litigations going on between the parties. Divorce at Guwahati filed by the husband, petition under Domestic Violence Act and maintenance case filed by the wife petitioner herein at Dibrugarh. Now, my lord, the husband and wife, my lord, they were residing at US. And this present petitioner, she was at US on a dependent visa. Because the husband, the respondent herein, had on his account, dependent visa was given to her and she was on dependent visa. Now, my lord, there is differences between them. He have left her company and now they are not staying together. And her visa is also not likely to be renewed. So she has already made all arrangement to shift to Dibrugarh and she have already shifted. So, and
where is she now?
she is at Dibrugarh, my lord. She is at Dibrugarh.
Presently, she is.
At present, as on today, she is at US. As on today. She went to bring all her belongings, my lord. She have to shift. I'll satisfy your lordship on that point also. Yes. So, and my lord, her house is at Dibrugarh. The marriage ceremonies were there at Dibrugarh. In fact, the registration under Special Marriage Act was also at Dibrugarh.
Okay.
Now, my lord, kindly come to their objection at page 83. Para 2, lordship have found it.
Yes.
Yes. That the petitioner has deliberately misstated her place of residence as Dibrugarh, Assam, whereas she continues to reside in Dallas, Texas, United States of America,
as is evident from the judicial order dated 22/10/2025 passed in the domestic violence case under section 144 BNSS file under section so and so on 15/10/25 by the petitioner, order dated 29/10. So Lordship, they have annexed two order 22/10/2025 and 27/10. 22/10 order is at page 87. Kindly come, my lord, to page 87. So I am reading page 88.
Yes.
Page 88. There is some confusion, my lord. I want to clear that confusion. Page 88, first, second, third, fourth paragraph, my lord. Learned counsel for the complainant, Lordship, have found.
Yes.
Learned counsel for the complainant in regard to petition number 2695/2025 submitted that the complainant stays at Texas, USA and will be leaving for USA on 26/10/2025, and it will be hardship for her to appear in the court on every date. This is what is reflected in the order. This is petition number 2695. I'll come to this again, Lordship. Lordship may come to the next order, then
It
together.
is in which case? DV case?
Yes. DV case, 41 of 2025. 2695 of 2025. Now, Lordship may kindly come to the other case, MR case, page 90. MR case order, page 90.
Yes.
Last part, my lord. White petition number 2737, 2025. Lordship have found it.
Yes.
Learned counsel for the petitioner has filed a petition under section 530 BNSS, praying for permission for the complainant to appear through video conferencing and to be represented to advocate on the grounds shown in the petition. Page 91. Learned counsel for the petitioner submitted that the petitioner is presently residing at Texas, USA and will be leaving India on 26/10/2025 and hence cannot appear on every date. Now, my lord, in their objection, their only contention and main contention is that since the petitioner herein is not staying at Dibrugarh and she is staying at Texas, as such, the case may not be transferred to Dibrugarh. Now, my lord, their petition did there. In the case, it was petition number 2695. Court copy 2695. Yeah, do that either. These are photostat copies of the certified copies, my lord. This petition number 2695, Lordship have found 2695. I have given two petitions, 2695 and 2737. 2695 is with regard to the DV case, Lordship. Kindly come to para 3.
Yes.
Yes. That due to unavoidable exigencies, the petitioner is required to travel abroad to rearrange her house and relocate her vehicle, which she left without planning and shall be leaving India on 26/10/2025. The said travel is necessary and bona fide in nature. That section 530 of the BNSS 2023 provides that proceedings inquiry trial may be conducted by the court through electronic communication, including video conferencing, whenever court deems it expedient, so and so, so and so. Now, my lord, my only contention here, I want to reply to their objection. They say that I am at, they said that court has already observed in its order that I don't stay at Dibrugarh, I stay at Texas. But what petition I had filed, this petition was signed by the petitioner herein, her signature is there on every page. Lordship have found Sukanya Bora, she have signed it. At para 3, she have specifically mentioned that she is going abroad only due to some unavoidable exigencies to rearrange her house and relocate her vehicle. Nowhere she have written that she stays there, she will be permanently residing there. Similarly, Lordship, kindly come to this next petition 2737. 2737, para 3. Lordship have taken up.
Yes.
Yes. That due to unavoidable exigencies, the petitioner is required to travel abroad to rearrange her house and relocate her vehicle, which she left without planning and shall be leaving India on so and so. Nowhere she have mentioned that she stays there. And in her domestic violence petition also, and in her maintenance application also, she have made specific averments therein that she stays at Dibrugarh. She was on a dependent visa, my lord. Now he have abandoned her at America. Now she also has to face so many legal consequences there. He have just simply abandoned her there. She cannot stay there. She don't have US visa. She was on a dependent visa. She has to come to Dibrugarh. Now he has already filed a divorce case against me. So, my lord, this thing I have.
Why divorce case was filed at Guwahati? How Guwahati got?
Lordship, that's the main thing, my lord. Her address is at Dibrugarh. The marriage ceremonies were conducted at Dibrugarh. Marriage was registered by the sub-register Dibrugarh, marriage register Dibrugarh, my lord. But they have filed it at Guwahati, my lord.
Showing how jurisdiction was brought.
My lord, it is for her to satisfy, my lord.
No, you have gone through the petition.
I have gone through, my lord. There are not such valid grounds, my lord, but one point on which he can file. There was one, we also went through, my lord, but there is one provision, my lord, in the act itself, for which we are not pressing on that point, on that law point, my lord. But otherwise also, my lord, she is a lady. If she has to travel from Dibrugarh to Guwahati by bus,
When the DB Act case was filed, in the DB Act case, the petitioner, the respondent has appeared.
Challenge the DB proceeding before this court, and we have got to stay on that.
They have taken part in this case.
No, we did not file a written statement till now. Having having received the notice.
I'll come to it. The maintenance, whether they have appeared.
My lord, they have, I'll just take the instruction, my lord. But appear koriche maintenance, sir?
No, yes, Lordship, last time we appeared.
Okay, appeared, my lord. She's made it clear, my lord. So, my lord, DV case, my lord, it is under special provision, and DV case says that DV cases can be filed in a place where the petitioner resides, where she works, etc., my lord. So, my lord, DV case can never be transferred. DV and maintenance, my lord, has to be at Dibrugarh, my lord. But this divorce case, my lord, can be transferred. Since two proceedings are already there at Dibrugarh, so this may also be kindly be transferred, my lord. This is the usual process which, my lord, court follows, my lord. Two matters are there, my lord, this may also go there. And she being a lady, she has to travel by bus all the way from Dibrugarh to Guwahati. She has to make arrangement at hotel because she has no house at Guwahati, my lord. It will be very problematic for her and very inconvenient.
Where the respondent stays.
Respondent, Guwahati, my lord, husband. And he filed a divorce, my lord. We did not file, my lord.
Okay.
We did not file, he filed it. He wants divorce, my lord. We have not filed for divorce.
Anything else?
But that's what, my lord. My lord may consider two things. One, the two proceedings are already at Dibrugarh, so this may also be sent to Dibrugarh. One. And second, that she is a lady, my lord. She has to travel all the way from Dibrugarh to Guwahati by bus. She has no private vehicles here. So she has to travel by bus, stay at hotel, my lord. It will be very inconvenient for a lady. These are, my lord, general considerations which court takes, my lord, in case of transfer, my lord. And, my lord, divorce being filed by him.
Lordship, first I'll satisfy Lordship. Lordship will go to Special Marriage Act. The jurisdiction, how I filed the case when I filed this case, the respondent was still in US, Lordship. And she is a working lady, highly qualified, Lordship. She was never in Dibrugarh, only till, I think, till class 10 she was there. After 12th, Lordship, she was in Bangalore, studying in Bangalore. She did her master's from Lancaster University, UK, Lordship. And he says that she's a lady, she's a poor lady. This is not the ground, Lordship. This is not a concrete ground for a transfer petition, Lordship. Supreme Court, in many of the judgment, they say every case has to be looked into different perspectives. It's not a hard and fast rule. She's a lady and the case will be transferred. So, Lordship weighs that 31, Lordship. Court to which petition should be made. This is for transfer or for filing of the petition, Lordship. Divorce, Lordship. Lordship will see 31 italic 4. Lordship has got it. Section 31.
Last
Last one. The petitioner is deciding where he can file. Now, The marriage was solemnized, we can file it there, that is Dibrugarh. The respondent at the time of the presentation of the petition resides, if the respondent would have been there, the parties to the marriage last resided together, they last resided in US Lordship. And then 3, in case the wife is the petitioner, where she's residing on the date of presentation, she is not the petitioner. For the petitioner, this is the one, Lordship, which attracts my case. The petitioner is residing at the time of the presentation of the petition in a case where the respondent is at that time residing outside the territories to which this act extends or has not been heard of as being alive. It is not this. It is with the attracting this section, Lordship. I have filed the case here because at the time of filing my divorce, she was not in India. She was in US. The moment she gets a notice of the divorce petition, Lordship, she immediately comes back to Dibrugarh. She files domestic violence. She files maintenance. And against the domestic violence, I have already filed 528 application before this court. We have a stay. Even against the maintenance, I'm filing this week.
Domestic violence and maintenance have been filed
That is
after,
a different issue, Lordship.
after divorce.
Yes, Lordship, after divorce. This, Lordship, I have put every WhatsApp messages, what they went, she went with in the thing was that, Lordship, he wanted an amicable divorce because there was no conjugal relation between them since 2021, although under the same roof they stayed, Lordship. He gave, and I have every proof of it. It's not a very weak case of mine. My case is placed on very strong footings. I have come before the court, Lordship. Here, Lordship, she instigates through some WhatsApp messages between she and her sister, Lordship.
No, we are not.
Don't
going-
touch that.
These are facts, my lord.
I know. Lordship, what happened here, Lordship? Now, what is the ground? She's a lady. She comes from a very affluent family from Dibrugarh. Let them put an affidavit that she doesn't have a residence in Guwahati. Let them put her in an affidavit, Lordship. And then Lordship will, I did not file that petition to sir. You must have it. Video. I don't have it. I'll just take it from them, Lordship. I will find the answer, Baba. Okay, Lordship will then come to the order, Lordship. Page 88, Lordship. Yes, Lordship. Operative process, Learned Counsel for the complainant in regard to petition number 2695/2025 submitted the complainant stays in USA. This is an order of the court, Lordship. Stays in USA. Stays at Texas, USA, and will be leaving for USA on 26/10/25. She doesn't mention, there's no record showing that she's coming back to India. Still now, Lordship, I did not put it because it is right. He has raised that point. I can prove it. She left USA, but she never came back to India because she is a green card holder of Canada also. I don't know where she went. This is one. And the grounds, Lordship. Now, what she does, she wants to be very comfortably sitting in US and doing the things from the video conferencing, Lordship. It's not that my petitioner stays always, he's also coming up and down US, Lordship, because he had to transfer to Mangalore, Lordship. A person on the way to get a green card on December left, he asked his company to transfer him to Bangalore, Lordship, because there was too much of things going on in the family, Lordship. And now the ground lady, this woman, Lordship, she studied her education was out of Assam, Lordship. She studied in UK, she studied in Bangalore, she worked in Singapore, she worked in USA, Lordship. Till December 25, she was earning nearly 1 crore rupees.
Report on the first occasion, Lordship state the judgment and decree passed by this, passed in the title appeal, Lordship. And considering the facts and circumstances, Lordship, the learned Munsif Court as well as learned trial, first appellate court passed injunction order, passed status quo order, Lordship. And that's why they could not do anything. Their intention is only to damage the land, as because they are apprehending that they will fail in that regular second appeal, Lordship. That's with a intention and they have not no crop there, only damaging the land, Lordship.
How? Where is the statement?
Whatever my learned brother has said, Lordship, beyond all pleadings in his petition, Lordship, only one paragraph, Lordship, the petition, para 7.
Okay, I'll come to you. Your only grievance is he started to cultivate.
Yes, started to cultivate, but did not grow crop here. Their intention is only to damage the soil.
Cultivate what?
We thought that they are going to cultivate paddy there, but they have not cultivated paddy. Nothing cultivated. Started to cultivate only and damage the woodland.
You don't have a.
That's why that is my. That's why that is a area problem. Or it is also admitted that the their land is original landowners. We are the original landowner. So my humble status quo may be maintained, Lordship.
Yes, Mr.
Tomorrow they can make a fishery there.
Lordship, may I?
Yes.
Just I would like to take a Lordship to the page 83 of the appeal memo, Lordship, regular second appeal, if possible. Page 83, the judgment of the first appellate court, Lordship, what they have adduced and the court has quoted, Lordship, and it will make the clear everything, Lordship. Para 22. May I read, Lordship?
Yes.
DW1 Abdul Rahman, that is now the second appellant, Lordship here, stated in his evidence that he is residing at Kathalwadi village for 20 years. Earlier, he was away for his livelihood. Disputed land is Patta 203. The last line starts, Lordship. I am cutting short. Prior to 1996, last line of that page 82, and starting line at page 83, left Bonghugi Gaon, the sweetland is at Bonghugi Gaon. When he was out of the land, was under the care of the plaintiff. Since 1996 till today, plaintiff is enjoying and possessing the 2 bighas 11 kathas of land. This is the soup land. He never gone any written document. This is the denial part there. Mandal is already there. He died in 1995. Exhibit 3 is not. Then in the last part of the Schedule B land is still under possession of the plaintiff prior to 1996. And even after that, plaintiff is plowing the land and enjoying harvest. This is his adjudication, Lordship. He never plowed the land. That is the plaintiff never plowed the land. The appellant has never plowed the land. Since 2011, plaintiff did not give him the harvest. No dispute arose regarding dispersion with the plaintiff. This is the sum and substance of the evidence of the second appellant, Lordship here. They are now saying we have never cultivated. Here is the admission. Always it is a cultivable land. We are cultivating land. We are in possession. A dispute arose regarding execution of a agreement for sale. And that is under consideration. Trial court has said in one way, first appellate court has reversed that finding. And now the matter is for regular appeal, second appeal also. So far injunction is concerned, their petition 7 only says the petitioner appellant begs to submit that opposite party started to cultivate over the Schedule B land. As such, if the injunction is not granted, then there are every possibility to change the nature and character of the Schedule B by the opposite party respondent, and in that case, petitioner have to face irreparable loss. How is it? Where is mere cultivation, which I am doing since 1996 or prior to that? Admittedly, prior to sale, he got share of the harvest, and then he transferred position, and with ownership, we are continuing in that part. There is a dispute regarding that agreement. Court will decide it on the second appeal on merit.
Lord Mr. U.B. Sharma.
Yes, Lordship.
Learned counsel for the applicant.
Yes.
Also Mr. S.K. Poddar, learned counsel appearing for the respondent. This interlocutory application under Order 39, Rule 1 and 2 read with section 151 of Code of Civil Procedure 1908 has been filed by the applicant in connection with regular second appeal number 199/2023, praying for
His lordship, if page 7 is the prayers. From page 7, lordship.
praying for grant of a temporary injunction during the pendency of the connected regular second appeal, restraining the opposite party / respondent, his main heirs, representative agents, etc., from changing the nature and character of the scheduled B land in any manner. Stop. Learned counsel for the petitioner has submitted that the learned counsel for the applicant has submitted that the applicant has filed the connected regular second appeal number 199/2023,
2023.
impugning the judgment. What is the first appellate court's judgment? Judgment date.
Reversing the judgment of the trial court and declaring the suit of the case.
Date is
Judgment dated 17/8/2023, lordship.
of the first appellate court,
First appellate court.
impugning the judgment
Judgment and decree
decree dated 17/8/2023,
Passed in title appeal number
passed in title appeal number
36 of the
36/2022, whereby
by the Honorable Civil Judge Senior Division.
by the Court of London, Civil Judge Senior Division,
Borpeta.
Borpeta, whereby the judgment of the trial court passed whereby the judgment and decree of the trial court, that is Court of London, Munsif
Number 1, Borpeta.
Munsif number 1, Borpeta, passed in
Title suit number
45/2013 was reversed, and the suit was decreed in favor of the respondent. Stop. Learned counsel for the applicant has submitted that the said regular second appeal has already been admitted, and the substantial questions of law have also been formulated in the said connected regular second appeal. He further submits that by which order the stay has been granted. He further submits that in interlocutory order,
Yes, lordship.
interlocutory application, or in the RSA.
In IA civil number 301.
He further submits that by order dated 10/11/2023, passed in IS Civil number 3301/2023, in connected with the in 23, this court had stayed the judgment and decree dated 17/8/2023, which has been impugned in the connected regular second appeal during the pendency of the connected regular second appeal. He further submits that the petitioners have started cultivating paddy over Schedule B land, within brackets suit land, and therefore there is every possibility of Schedule B suit land. He also submits that the suit land is not an agricultural land, but a residential land. Hence, if he is allowed to cultivate the said land, it would change. There is every possibility that the nature and character of the suit land would be changed, and he would suffer irreparable loss. He therefore seeks grant of temporary injunction against the respondents from cultivating this said land during the pendency of the connected regular second appeal. On the other hand, learned counsel for the respondent has submitted that the suit land is in possession of the respondent since long, and they have been cultivating over the said plot of land since the year 1996. Any other submission?
It will not, neither balance of convenience is in favor, no change, pitch of change of nature, and
He further submits that by
except the prima facie case, they have nothing else.
that
Lordship, may I submit, Lordship?
no. What do you want to submit?
I want to submit, Lordship, the learned counsel for the respondent indicated paragraph number 22. Here, they are saying about the year 1995, about 30 years ago. Now, 80% or at least 60% of the cultivating land during 1993 are now residential.
No, I have understood you.
That's why it is.
I have understood.
They till 95 they cultivated. Defendant has stated that till 95 they cultivated, but hereafter, before filing of this case, they did not stop. They stopped cultivating. We did not allow them to cultivate there.
Okay.
Thereafter, Lordship, thereafter, in that year 2009, they forcefully taken the position of the suit land, and during that period, after the suit was filed and counterclaim was filed, Lordship, both the learned trial court and the first appellate court, considering the facts and circumstances of the case, as well as going through the evidence, Lordship, the suit temporary injunction was granted by both the honorable, and that's why the suit land was till that it was safe, but now they are going to damage them. That's why at least status quo order may be maintained till disposal of this appeal, Lordship.
I pointed out that they have even received harvest till 2000.
Prior to 1996, Lordship.
Yata paragraph,
Admission.
yata paragraph petitioner submission on the one. Agot. Learned counsel for the petitioner. Learned counsel for the applicant has also submitted that even during the pendency of the title suit before the trial court and during the pendency of the first appeal, there was an order of status quo operative in respect of the scheduled B land. And therefore, during that period, the suit land was not cultivated. Now, itu uporo দিব. Learned counsel for the respondent has further submitted that the no case for grant of temporary injunction has been made out by the applicant in the instant case. He submits that apart from the fact that there may be a prima facie case in as much as the second appeal has been admitted and the impugned judgment has been and the execution of impugned judgment and decree has been stayed. However, they have failed to make out a case for showing irreparable loss to the applicant and that the balance of convenience in their favor. He submits that as from the impugned on perusal of the impugned judgment itself, it appears that the possession of the question of possession of the present respondent over the suit land is not disputed. He submits that even the appellate court had observed that since
It is the admission of the.
whose
It
admission
is
is
the admission of the appellant, Lordship. DW1. Not.
as
observation, Lordship.
DW1.
As DW1, Lordship.
Even on perusal of the deposition of the present appellant as DW1 before the trial court.
DW1, para 22, DW.
DW
22, 22.
Abdul Rahman.
I'm apologize, Lordship.
DW1. DW1. It appears that he admitted in his testimony that that since 2011 the present respondent did not give any harvest to him, which itself indicates that the land was plowed by the respondent since 1996. So I have considered the submissions made by learned counsel for the petitioner. This court fails to understand how a plot of land which is plowed for the purpose of cultivation would change the nature and character of the said land so as to damage it. The only contention of the learned of the applicant in this interlocutory application for grant of temporary injunction is that the scheduled land, being a residential land, is put to cultivation. These are category of land categorized in revenue records.
No, where? It is a total out of 7 bigha, 11 lessage. 2 bighas were sold and 5 bigha is under possession. That is not a residential, but it is purely our cultivable land. Our livelihood is depending on that also.
Though
Another plot of land nearby, Lordship, we have also, this is, if your Lordship kindly goes through
They
the.
have no pleading
See,
that is a
If
residential.
your Lordship
Pleading,
kindly
no
goes
way.
through the schedule of the
Neither in the suit, neither.
boundary of
nor in
the land Lordship, it is situated nearby a public road Lordship, PWD road. The very valuable land Lordship.
though the applicant has not produced any document to show that the scheduled plot of that the suit land is a residential land, is categorized as non-agricultural land, is categorized as residential land in revenue records. However, even if same is assumed to be residential land, by mere putting the said land paddy cultivation by the respondent with whom the possession of said land is since when?
Since 1996.
Since
In 1996,
1996.
supposed to
As
possess.
per our condition since 2009.
Since 1996, within bracket as per the submission of
As for the admission also.
as since 1996, it would, in the considered opinion of this court, would not in any manner degrade the status of the said land or damage the same or to stay or to change the nature and character or to change its nature and character. Hence, the court is of considered opinion that the applicant has failed to show the existence of essential ingredient which are necessary for grant of essential ingredient like balance of convenience, prima facie case, and suffering of irreparable loss by the petitioner in this case. For the reasons stated above, this interlocutory application is found devoid of any merit and accordingly dismissed.
Obliged.
Highly obliged, Lordship. I have a humble submission, Lordship. As the.
I may have to make some corrections.
Lordship, I have a submission with respect to the connected regular second appeal, Lordship.
Yes.
Lordship, as there, the learned, the honorable court has refused to grant injunction order, Lordship. With regard to that, Lordship, that the connected regular second appeal may be fixed for hearing, Lordship. My humble submission, Lordship. Otherwise.
No, it will be otherwise fixed for hearing. If you need,
Yes, Lordship. As because they are cultivating, Lordship.
yes,
Lordship, I have no.
in main appeal, RSA. Same councillor নাম একে থাকিব. Since the appearance of parties, the records have arrived.
Yes, Lordship.
Since the appearance of parties is complete in this case, and since the records of the trial court as well as first appellate court have been received, where are the records? Records, I say, have been received. This appeal is ready for hearing. Accordingly, list this matter in the month of January. In the month of January on a date to be fixed by the ministry for hearing.
Highly obliged. After second week, Lordship, after Bihu vacation, I will not be available the first part.
In the second part of January. On
Highly
a date to be fixed by the.
Then 42.
Wait, please, your lordship. Lordship, there is a delay of 72 days.
Before that, Lordship, we want some time for filing objection to their.
You'll be filing objection.
Yes.
Heard, Miss, what is your name? S. Sharma, learned counsel for the applicant slash applicant. Also heard Mr. U. Datta, learned counsel for the respondent, who raised for some time for filing written objection against the application for condemnation of delay filed by the applicant. Prayer is allowed. Let this matter be listed after 2 weeks. How much time you want?
They have to come from, what's it, Dhemaji.
After three
vacation.
Three,
Yes.
after 4 weeks on a date to be fixed by the ministry.
Obliged.
May I please, Your Honor? May I please, Your Lordship? Your Lordship, today is fixed for orders, Your Lordship. In the RSA that we have filed, the conducting counsel missed out to bring on the record the name of the legal head, Your Lordship, of respondent number 2 and 4, Your Lordship, in para 4, Your Lordship. Your Lordship, during the course of the appeal, they have been expired, Your Lordship. Respondent number. Respondent
No,
number
then
2.
then you have to file substitution petition. During the course of which appeal? Where is the RSA? What is your prayer? Whom you want to implead?
Respondent number 2 and 4, your lordship. Legal heirs of respondent number 2 and 4. It is in para 4, your lordship. Implement application. Sri Suchindra Brahma and Tilak Brahma.
When respondent number 4 and 2 expired,
During the course of the trial, appeal, your lordship,
which first appeal?
first appeal. Yes, sir.
Third, Mr. What is your name?
A.M. Siddiqui, your lordship.
A.M. Siddiqui, learned counsel for the applicant. This RSC is yet to be admitted.
Not admitted. Your
This interlocutory application has been filed by the applicant / appellant in connection with RSA number 2024. Bring for whom you want to implead, where
Respondent number 2 and 4, your lordship.
playing for
The legal heads of respondent number 2 and the names are reflected in para 4, your lordship. Page number 4 of my application.
paying for rectifying the names of respondent number 2 and 4 in the memo of appeal of the RSA number 77/2024, 2025. And that counsel for the appellant submits that both the aforesaid respondents had expired during the pendency of title appeal number 9/2023. However, due to inadvertent error, due to inadvertence, their names have been shown as respondent number 2 and 4 in the post title of the memo of appeal of connected regular second appeal number 77/2024. He submits that instead of Heger Brahma, HEGR, who has been shown as respondent number 2, the name of his legal heir, namely Tilak Brahma, is to be shown as respondent number 2. Whereas instead of Sachindra Brahma,
Pramila Brahma, your lordship.
Pramila Brahma you have shown as respondent number 5. Sachindra Brahma. The names of Sushendra Brahma and Pramila Brahma has to be shown as respondent number 4 and 5. As they are the legal heirs of deceased respondent Sachinder Brahma. So, since the connected RSA, the notices are not yet issued and same is not yet admitted, same is yet to be admitted, the prayer for rectification is allowed. The applicant is allowed to rectify the memo of appeal of the connected RSA number 77/2025 accordingly, and file a corrected cost title in the said memo of appeal. This file a corrected cost title in the said memo of appeal within a period of 1 week from the date of 2 weeks from the date of this order. This interlocutory application is accordingly disposed of. List the connected regular second appeal for admission. No, for hearing under order 41, Rule 11 of the CPC after 2 weeks. After 2 weeks, stop. You rectify your memo of appeal within 2 weeks.
Yes, sir.
44. Next page, Your Lordship. Before my senior starts, my lord, my colleague has made in mention for in the morning, my lord, for seeking short adjournment, my lord. Since my
My lord, I'm appearing for the appellant, my lord, in this matter. But I'm sorry, my lord, we are on the virtual mode today. My lord, this matter, my lord, was moved, and my lord, there's an order which has been passed on the 24th September 2025.
For whom you are appealing?
My lord, I'm for the appellant, my lord, the executor and the plaintiff, my lord, before in the suit. My lord, I'll tell my lord what's happened here. My lord,
Yeah,
had
just
also.
a minute. Just a minute.
Well, I've
Yes.
sought for little accommodation. In the morning, my colleague has made a mention, my lord, my senior Mr. B. Klausik on very and my lord, engaged senior counsel also in legs in court number 1, my lord, for the departed hearing.
Who is the counsel?
My lord, Dilip Mojumdar, my lord.
They are seeking an adjournment, short accommodation.
My lord, my lord, only difficult, my lord, then, my lord, the only thing is, my lord, then the order has to be extended. My lord, there's also, if my lord looks at, my lord, the order of 24th September, my lord, there, my lord, one correction has to be made, my lord, with regard to the number of shares. Three things. One, my lord, a very serious thing. First, my lord, may I just do away, my lord, with what, my lord, in the last
Take up on the next week, Thursday.
paragraph, my lord, we'll see, my lord, it's 816918. My lord, it's 816918. That should be, my lord, 861918 shares.
Which?
My lord, last line of, my lord, the injunction order, my lord, the order which has been passed.
3216.
IA 3216 of 2025.
Last line.
You are assisting him.
My lord.
Okay. And what should be there?
My lord, it should be, my lord, 861 instead of 816. It should be 861918.
We'll make that rectification.
And my lord, secondly, my lord, and more importantly, my lord, what has happened? My lord's court had restrained, my lord, respond number 2, my lord, from transferring the shares lying, my lord, in the account of, my lord, the opposite party number 3, which is, my lord, the HDFC Bank. Now, my lord, we get a letter, my lord, we find, my lord, that on the basis of, my lord, the trial court's order, which was, my lord, obviously, my lord, stayed with this order, my lord, they have transferred it. So they're in contempt of, my lord, this court's order.
Well, let them bring on.
I do not understand, my lord, how, my lord, they could have done that. It's in direct violation of, my lord, this order which has been passed. Now, my lord, we find that, my lord, this respondent number 2, has transferred into her, my lord, own account maintained with, my lord, respondent number 3, which is the bank. It's in contempt.
Okay, you approach this court by filing appropriate
Well, I will respond.
application.
We will
instead
do
of
that, my
making-
lord. We will
instead
do
of
that, my lord,
making-
enforcement.
We are extending the interim order.
Very well, my lord. Kindly do that, my lord. And then, my lord, may I just make one more request? My lord, if the 4th of December, if it's possible, my lord, I told my lord, is it possible, my lord, that, my lord, we can come down physically, my lord, either the 4th or the 5th of December, my lord, to have this matter, my lord, done in physical, my lord, we would also be like to there, my lord.
Thursday, hearing.
This IA is for what
My lord,
relief yours?
my lord, for stay and, my lord, for injunction, or, my lord, the impugned order. My lord, may I just, my lord, if my lord wants, my lord, I can take 1 minute just to explain what the matter was, my lord.
Yes.
My lord, I am.
Asking for adjournment today, my lord, my senior is also in.
It's all right. My lord is not. My lord just wants to know what the matter is.
I am not saying that your prayer will be rejected.
Yes.
Like-
My lord, I'll tell my lord what's happened. My lord, the plaintiff, my lord, the original plaintiff, my lord, Mr. Borua, my lord, had 861918 shares, my lord, in this company, BNL Limited. It was, my lord, held in, my lord, a joint account where, my lord, he was the first named holder, and, my lord, his daughter was, my lord, the second named holder. My lord, this was done for operational convenience. Now, when he wanted, my lord, the shares to be transferred back, she resisted. That's why, my lord, Mr. Borua filed a suit saying that the share belongs to me. Exclusive ownership is with me. Now, my lord, after filing the suit, my lord, after there was an order but which was passed in 2012, my lord, he passed away. The executor, my lord, Mr. Chatterjee, who is the executor to the last will, my lord, made an application for substitution. My lord, that substitution.
Who are you?
My lord, I'm the executor, my lord, to the estate.
Okay.
And the appellant. And, my lord, the plaintiff now substituted as the plaintiff. So, my lord, the substitution application was pending for quite some time. Then, my lord, in 2025, the substitution was finally allowed. And, my lord, I was substituted as, my lord, the plaintiff. Now, my lord, then the injunction application came up for hearing. So, the order which was passed, my lord, on 13th August 2012, and, my lord, the other side also came and said they have no objection in the order being continued. The learned judge, my lord, for some reason, has now, my lord, vacated that order and dismissed my petition. That is why I came up in appeal. And, my lord, was pleased to pass an order saying that, my lord, the daughter will not be able to transfer the shares held in the, my lord, dematerialized account, my lord, which is known as demat account of, my lord, HDFC Bank. Now, in spite of this order, after the order has been passed, my lord, she's gone ahead and, my lord, had it transferred. And, my lord, HDFC has also been served, my lord, of the order, so they could not have done it. And under the will of, my lord, Mr. Borua, this goes to a family trust. The shares could not have been transferred. And the daughter, my lord, is a second named holder. The Mr. Borua, my lord, the deceased testator, is the first named holder. So only the executor has the right to the shares, my lord, and not the, my lord, not the, my lord, daughter. That's, my lord, in terms of law, and, my lord, also in terms of, my lord, the articles of association of the company. And that is why, my lord, we made all this submission. And then, my lord's court was pleased to pass an order, my lord, which I showed on the 24th of September.
Okay. Heard Mr. R. Banerjee, learned senior counsel assisted by Mr. A. Sahewala, learned counsel for the applicant. Also heard Mr.
My lord, S. Hazarika for response number 2.
My lord, I appear for response number 3, my lord. On instruction, I'm appearing today. I'll be filing my Ukalat number very soon.
S. Hazarika, appearing for respondent number 2. Also heard Mr. R. Chakraborty, who submits that he has instructions to appear for respondent number 3 and would be filing his Vakalatnama very soon. Learned counsel for respondent number 2 has prayed for a short accommodation on the ground of personal difficulty of the conducting counsel for the respondent number 2. He submits that the leading senior counsel for the respondent number 2 is on legs in a different court, and therefore his prayer for adjournment may be allowed. Stop. On the other hand, learned senior counsel for the applicant submits that that the interim order granted by that in that event interim order granted on 24/9/2025 shall have to be extended. However, he points out regarding a clerical mistake, typographical mistake in the said order. He submits that in the second last line of the said order, number of equity shares mentioned is within bracket 816918 within inverted comma 816918 instead of 861918, and same shall have to be rectified. So I have considered the submissions made by learned counsel.
I'm sorry, my lord, I'm so sorry, my lord, interrupting, my lord. I'm so sorry. My lord,
Yes.
also, my lord, my submission, my lord, that they're in contempt. And my lord, the response number 3, my lord, should reverse.
Yes,
My lord,
yes.
response number 3, my lord, should reverse, my lord, the transfer of the shares immediately. That's
My
my
lord,
prayer
no
as well.
I don't have instructions.
No, let-
Not, my lord, my learned friend, response number 3, my lord, which is, my lord, the HDFC Bank.
That is his submission on.
Yes, that's-
He further submits that in spite of the order of injunction, order of order restraining, in spite of order dated 24/9/2024 by this court, restraining the respondent number 2 from transferring the equity shares of BNA Limited Company, which are lying with respondent number 3. The respondent number 2 in committed contempt of the court by violating the directions of this court and has transferred the share. To whom it has been transferred?
My lord, to herself. My lord, it was lying with response number 2, my lord, in the account of, my lord, the estate, the testator's account. They have now, my lord, transferred it, my lord, as if, my lord, it's her shares into her own account.
Transferred. He further submits that in under such circumstances, the respondent number 3 may be directed to what? Directed to?
My lord, directed to, my lord, immediately retransfer it to, my lord, the testator's account, my lord, the estate of, my lord, HP Borua. That's where the shares belong.
Directed to retransfer it to
the account of the estate, my lord, estate of the deceased.
to
My lord, to the estate of the deceased.
bring the position of status quo ante. No, he continue. To retransfer it to the estate of deceased S.D. Borua. Stop.
HP Borua.
HP.
HP, my lord.
HP Borua. Stop. After considering the submissions of learned counsel for the
My lord, I'm sorry to interrupt, my lord. On the submission made by my learned senior, my lord, on the transferring of share from the respondent number 3 to
you don't have any instruction.
My lord, I don't have, because my respondent number was staying in USA, my lord. Till now, I don't have any instructions.
Well, LDF will confirm that.
My lord, therefore, my lord, we would like to reply on that, my lord.
LDF will confirm.
If they bring on record, my lord, we'll
Bring on record.
let them bring on record, my lord. Verbally, they are submitting, my lord, now.
We will bring it on record.
After considering the submissions of learned counsel for both sides, the prayer made by learned counsel for respondent number 2 for short accommodation is allowed. let this matter be listed.
Can be on 8th of December.
But we'll also file objection. We have not.
Because
yet
I have
filed
to take
the-
instructions, my lord, I'll put in record.
My lord, I was requesting, my lord, for 4th or 5th, my lord, of December, if possible, my lord.
Any other date
4th,
suggested
5th.
after that?
No, then, my lord,
Weeks
uh,
ahead, my lord, as per contract.
9th, my lord, if it commends to my lord.
9th. Let this matter be listed on, no, because 9th of December.
Great.
One. The figure of equity shares mentioned in order dated 24/9/2025 passed by this court in this interlocutory application shall be read as 8,61,918 instead of 8,16,918. Stop. As regards the allegation of violation of the injunction, violation of the restraint order passed by this court, the applicant may bring the same on record by filing appropriate applications.
We'll do that.
Interim order may continue.
The interim order dated 24/9/2025 shall continue till next date. Arvita. The respondent number 2 and respondent number 3 are allowed to file written objection, if any, before the next date fixed. List this matter on 9th of December.
Grateful. Grateful.
The condemnation petition lawsuit of 82 days allowed.
Who is for the other side?
First detail lawsuit.
Notice has not been issued. Heard Miss S. Nazneen, learned counsel for the applicant. This is an application under Section 5 of the Limitation Act. Prayer for condoning the delay of 82 days in preferring the connected MAC appeal by the applicant. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly. Next item up. Yes.
Filed this delay condonation application, but citation of this citation, I am not required to file any delay condonation. Because this is a application under 227 of the Constitution of India.
And then why have you filed?
Here,
Then
my senior has advised me to file the
Because it is civil revision.
No, but for 227, there is no
No limit.
period of limitation prescribed. Heard Mr. R.K. Moore, learned counsel for the. This is item number 33. Learned counsel for the applicant. Also heard Mr. N. Arnold, learned counsel for respondent number 1 and 2. Learned counsel for the applicant has submitted that though the applicant has filed and this instant application for condonation of condoning the delay of how many days? How you have computed
24, and I challenge to 3 orders.
delay? How
Altogether 104 days, man.
Of,
Altogether 104 days.
of 104 days. However, he submits that since the connected CRP within Wicket IO has been filed under Article 227 of the Constitution of India, for which no prescribed period of no period of limitation has been prescribed by any law. Hence, you are withdrawing this.
No, but I submitted the judgment.
Judgment is not required. Why judgment? There is nowhere limitation has been prescribed.
So the connected appeal in the revision may be decided by the Honorable Apex Court in
He submits. No, this is delay in laches.
yes, madam.
In support of his submission, he has cited a ruling of the Apex Court in the case of Bithika Majumdar and another versus Sagar Pal and others, reported in 2017 2 SCC 748. Hence, he prays for allowing the petitioner to withdraw this instant interlocutory application and also prays for a direction for registering the connected CRPIO. The prayer is allowed. This interlocutory application is dismissed on withdrawal. The registry is directed to register the connected CRPIO and list the same in motion column after a week. You have anything?
Let me calculate
Motion column
by fixing a date, man.
in the next week.
Hello? Next week.
In the next week on a date to be fixed by registry.
Much.
Item 47 is also 47.
47 આખો માંથી દ્યો.
47 today.
Item 47.
47 or 37?
47 today has a delay condonation petition, Lordship, in filing the MSC appeal, Lordship.
My lord,
Yes.
my lord, I am on behalf of, as per instruction, on behalf of respondent number 125, my lord. 124, sorry, 124.
Yes.
So, my lord, color number will be filed shortly from the respondent number 1 and 4.
Yes. Anything else?
My lord, 50% may be directed to deposit from the awarded amount.
No, their MSc appeal has not yet been registered.
Yes, my lord.
You are only on 50%.
My lord, then I will file an objection if the copy will serve. Copy will take from the learned counsel from the appellant.
Heard Miss D.D. Burman. You are appearing for
Respondent number?
Learned counsel for the appellant. Also heard Mr. What is your name?
My lord, B.R. Das.
B.R. Das, learned counsel appearing through video conferencing mode who submits that he has been instructed by respondent number 1 to 4 to appear in this interlocutory application. He also submits that he would be filing his Wakalatnama very soon. He further submits that the said respondent would also be filing their written objection against the prayer for condonation of the delay. Stop. As against 5 and 6. Stop. This application under section 5 of the Limitation Act 1963 has been filed by the applicant insurance company for condoning the delay of 150 days in filing the connected MAC appeal, whereby the judgment and award passed on 30/4/2025 by the Motor Accident Claims Tribunal number 1, Sibsagar, in MAC appeal number, in MAC case number 39/2021 has been impugned. Issue notice to the respondents. Since Mr. Das,
PR Das, my lord.
since Mr. B.R. Das would be appearing for respondent number 1 to 4 by filing formal Wakalatnama, by filing Wakalatnama, no formal notice need to be issued to said respondent. As regards respondent number 5 and 6, the applicant shall take steps for issuance of notice upon the said respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, least accordingly. After 4 weeks.
Highly obliged, my lord.
3. Manly, say.
34.
That you have mentioned.
3/3/2025.
34 to काटी दियो. 3/3/2024. 25.
My lord, 26. Correct, my lord. Sorry.
48.
Highly obliged.
In 48 lodges, there is a delay of 44 days in preparing this MSA.
Heard Miss D.D. Burman, learned counsel for the applicant/appellant insurance company. This application under section 5 of the Limitation Act has been filed by the applicant insurance company, praying for condoning the delay of 44 days in preferring the connected MAC appeal, whereby judgment and award dated 18/7/2025 passed in EC case number 43/2024 by the employees compensation, by the commissioner, learned commissioner, employees compensation board has been impugned. Issue notice to the respondent. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
Okay.
Process is a delay condemnation petition. It has come up for the first time So lordship notice may be issued at this stage.
Heard Miss Apiani Learned Counsel for the applicant. This application under section 5 of the Limitation Act has been filed by the applicant insurance company, praying for condoning the delay of 32 days when preferring the connected appeal, whereby the judgment and award dated 26/5/2025 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro in MAC case number
2531.
2531/2018 has been impugned. Issue notice to the respondent.
She will take steps by usual process.
No, but in addition to that, by speed post also. The applicant shall take steps for issuance of notice upon the respondents by usual mode as well as by speed post within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Your lordship, this is also a delay condemnation petition. It has also come up for the first time, your lordship.
Same counsel. This application under section 5 of the Limitation Act 1963 has been filed by the applicant insurance company, praying for condoning the delay of 579 days in preferring the connected appeal, whereby the judgment and award dated 14/12/2023 passed by the Motor Accident Claims Tribunal number 2, Sonitpur in MEC case number 51/2022 has been impugned. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List according.
Please, your lordship. Condemnation of delay, 851 days, lordship.
Heard Miss G Gogoi. Heard Miss A Gogoi.
So, page number 5, lordship, paragraph 3, there will be typographical mistake. I may be allowed, lordship, to correct this.
Heard Miss G Gogoi, learned counsel for the applicant. This application under section 5 of the Limitation Act has been filed by the applicant, by the applicants. You are claimants
Yes.
by the applicants, praying for condoning the delay of 851 days in filing the connected MAC appeal, whereby judgment and award, whereby judgment dated 24/2/2023 passed in the MAC case number 58/2017 by the Motor Accident Claims Tribunal Lakhimpur, North Lakhimpur, has been impugned. issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by speed post. By speed post as well as by usual mode within a week from the date of this order. Returnable after 4 weeks. Learned counsel for the applicant submits that a minor typographical mistake has been crept in where what
The last sentence, Lordship, this solo bed, there must be earner instead of winner. The last line, Lordship. Page 5, Lordship, last line.
yes,
And after his
only one word.
No, 2 words, Lordship. After his death instead of after his accident, Lordship. There is death instead of accident, Lordship.
Okay, लिख ले. Last line. In the last line of page 5 of the instant condonation, delay condonation application, in as much as in place of word earner, the word winner has been mentioned, and in place of accident, the word death has been mentioned. The applicant is allowed to rectify the said defect and submit a corrected page 5. You correct the page 5 and submit corrected page 5 of the petition before the next date fixed. List accordingly.
All right. Lordship, this application is for condoning the delay of 2 days in filing the regular second appeal, Lordship.
Substitution in filing of
Yes,
2 days.
yes, Lordship.
Yes, then
Lordship, yes.
no, service is complete.
Yes. As per 17/11/2025.
Heard Miss K. Bora, learned counsel for the applicants. Mr. Bhattacharya, you are appearing for state respondent. Also, Miss. But you may not object, only 2 days.
That may be allowed.
The Mr. K.
Why don't
Bhattacharya.
we record that?
Yes, Mr. K.
Only 2 days.
Only 2 days. Mr. K. Bhattacharya, Learned Government Council appears for state respondent number 1 to 4. This application under section 5 of the Limitation Act has been filed by the applicant for condoning a delay of only 2 days in preferring the connected regular second appeal, whereby the judgment and decree dated 29/8/2017 passed by the Court of Learned Civil Judge Karimganj in title appeal number 1/2017. . কি লিখিলো has been impugned. Has been impugned. By the impugned has been impugned. Stop. The learned counsel for the appellant has submitted that the delay of only 2 days has been occasion in preferring the connected regular second appeal, and said delay has been explained by the applicant in paragraph number
Actually, paragraph 4 of our,
paragraph number 4 of 4 and 4, 5.
and 5.
2, 3, 4, and 5 of the application. On the other hand, learned Government Counsel Mr. Bhattacharya submits that since the delay is of only 2 days, he does not have any objection if the same is condoned. Considering the submissions made by learned counsel for the parties, as well as considering the grounds shown by the applicants in their application to be sufficient grounds which prevented them from approaching this court which prevented them from filing the connected regular second appeal within the prescribed period of limitation, the delay of 2 days is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected regular second appeal and list the same for hearing under order.
The RSA, the notice has to be served in the state of Assam office.
We will again for no RSA.
It will come for another date.
It will come for because RSA, it is RSA. Substantial question of law has to be formulated. Only
No, but
there.
the state of Assam, the notice will have to be, they can give without notice also.
Oh, yes.
Copies may be served.
No, we may not issue notice in RSA.
Yes, yes.
Suppose they fail to.
Yes, that is what I'm saying. Notice need not be served, but a copy may be served privately. So that by that they generally do one copy. So that in the office of not to me, the office of the state of Assam.
That you may do. I'm not reflecting it in. Let the connected RSA be registered by the registry. Huh? Registration, we say. Let the connected RSA be listed for hearing under Order 41 Rule 11 of CPC after a week. Listed. You have 15 minutes only. What is the matter?
He filed a claim petition. It was allowed, 66,000 was, compensation was paid. Then the insurance was ex parte in that particular petition application. Then the insurance again file a review petition and my compensation set aside.
Or set aside.
Two grounds they have filed that I was riding the motor vehicle cycle So no other vehicle is involved in.
So it may take some time. Some time. Mhm. Monday problem. We are not on any hearing day. Heard Miss SSJ Ahmed. SSGA. Heard Miss SSGA. Learned. Yes, Miss SSGA, learned counsel for the appellant. Also heard Mr. AJ Soikia. Learned counsel for respondent number 2. This appeal could not be taken up for hearing due to paucity of time. Let this matter be listed, but choose after 2 weeks on a date to be fixed by registry. Let the registry fix the date. After 2 weeks on a date to be fixed by registry. Remaining hearing matters.
Lordship.
Others, we don't have time now.
Lordships, time may be allowed. And in the meantime, a present disability certificate. Earlier, it was a temporary disability certificate. And now, the claimant got, the appellant got the permanent disability certificate. That may be allowed to be submitted by way of additional affidavit.
During appeal, order 41 rule 27 petition you have to file. You have to file an appropriate application. You may file an appropriate application. Today we are showing these matters as leftover matters. You may file an appropriate application.
Fine.
I am not reflecting it in the orders.
Additional affidavit may be.
That is at your own risk. I am not suggesting anything.
Only one certificate.
So other matters are shown as leftover.
I have a small query in item 54.
Yes.
Lordship, this may be taken up in the next week because there is urgency from the other side. And I have assured that on any a date may be fixed in item 54. It should not take much time.
No, this is normal submission of all lawyers, that it will not take much time.
Lordship, I paid a date may be fixed because from the other side, the lady is suffering, so there is an request.
4th of December. Okay, 4th of December.
Lordship, my case is of 2007 accident. But then earlier it was interlegal application also. That is why it was admitted in 2019.
9th of December.
So on that,
9th of December.
On that.
9th of December.